I want to say thank you to everyone for being here tonight. I need to say a couple of things at the very beginning because we're not following our exact usual procedure. Of course, Judge Patrick Deakins, as the county judge, presides over these meetings regularly, and I am not him, of course. He asked me to fill in tonight. I'm one of the justices of the peace. For those of you, if you're here for the first time, I wanted to mention that. I'm David Wilson, usually representing District 2, but he asked me to chair tonight. I also wanted to say that for the benefit of whoever might be tuning in. Before we proceed, though, I needed to ask what is the pleasure of the court concerning the chairmanship this evening. Is there a motion? Judge Dean?
Yes, thank you. I'd like to make a motion that J.P. Wilson chair the Quorum Court this evening.
Okay, we have a motion. We have a couple of seconds. I think one came from J.P. Lyons, the second. All those in favor of that, please say aye. Aye. All opposed? We don't hear any, so I guess I will remain in this role just for this evening. I want to give you my word that next time we meet, I'll try my best to go back to my usual spot and try to be a little quieter. But I will have to speak to some things this evening. I wanted to say at the very beginning, of course, June is a month in which we have a lot of special observances, some holidays, some historical events, and you're aware of that. I wanted to mention it. This leads right into where we usually begin, but on the 28th of June, on that day in history, at the Constitutional Convention in 1787, on that date was when Benjamin Franklin made a very remarkable statement to help them get past an impasse at that meeting. Of course, at that time, they were trying to work out a new plan for our government. They were having trouble building consensus on almost every issue, and he made a very short but eloquent speech. Part of it, he said, "I've lived a long time. The longer I live, the more convincing proofs I see of this truth that God governs in the affairs of man." And he went on to say that if a sparrow cannot fall to the ground without his notice, is it probable that an empire could rise without his aid? Of course, Benjamin Franklin could say that better than most of us. He went on to make a motion that they begin each session with prayer. And that, as we are aware, that tradition continues to this day in the United States Congress. It's also one reason that we begin our sessions with prayer here at the Washington County Quorum Court, and we will do that this evening. So if you would at this time, please stand. And you'll have to forgive me, I forgot who was tabbed to voice our prayer this evening. J.P. Dean, will you voice our prayer?
Thank you, Chair. Heavenly Father, I'd like to thank you for all the things that you've given us. And I'd like to ask you if you could help everybody to grasp onto the growth in the area and try to accept it to the best you can. And, just show kindness and everybody get along. So, thank you and amen.
Amen.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, J.P. Dean. I also wanted to say that since this isn't my usual role, I'll beg for patience on the part of everyone here this evening as we work things through. If we slow down sometimes, it's because we want to be sure and do things right. So appreciate your understanding in that manner. On our agenda, you can see that we need to adopt tonight's agenda. Do I have a motion concerning that? J.P. Koger?
I have a motion to remove item 9.7 from the consent agenda, or I want to remove item 9.7 from the consent agenda. And I guess it can go in right before the committee reports at the end.
Okay, please restate that for us, please. To remove it from consent agenda?
I'm sorry.
Would you please restate what your motion is?
Yes, I would like to remove item 9.7 from the consent agenda, and I guess the place for it to go would be right before we, but right now what we have as 17 is committee reports. I mean, I suppose it would go there. That's okay.
You can, yeah, that doesn't take a vote, because anybody can remove from the consent agenda, and it doesn't require that. And you can either place it, you can just make it the new item there, or you can put it at the end. It's up to you.
Okay, your suggestion is so noted. It will stand separately from the consent agenda.
Thank you.
Still be item 9.7,
Thank you.
and we will take it up in that order. Anyone else? J.P. Lemming?
9.2, Brian, will we have an opportunity to visit a little bit about that and ask some questions before it's voted on? If not, I'd like to remove it from the consent agenda.
Yeah, so, yes, we will. Will always be a discussion time, even for the consent agenda items that we can talk about before we vote on them.
Before we vote,
Absolutely.
okay, thank
Yes,
you.
sir.
Is there any other word at this point? Seeing none, we will,
Motion to adopt the
do we have a motion to accept the agenda as amended? Okay, I hear a motion from J.P. Ricker and a second by J.P. Lyons. Is that correct? All those in favor? Aye. All opposed? Thank you. The agenda, the amended agenda will stand approved. I wanted to ask if there's any preliminary motions before we proceed further this evening.
Yes, there is. I'd like to make a motion that all ordinances and resolutions be read by title only.
Okay, I hear a motion that they be read by title only by J.P. Dean. The second, was that J.P. Rio Stafford? All those in favor? Aye. All opposed? Thank you. Those will be read by title only this evening. Are there other preliminary motions at this point? Thank you. Seeing none, we will move on to the next section on our agenda, and that would be citizen comments. Are there some that need to be made this evening? You are welcome to approach the podium. You can even form a line if you wish to speak there. Of course, the rules that we traditionally follow here are that each individual has 3 minutes to speak to any relevant issue that they may need to speak to. And we ask that the entire time be given 15 minutes so that we can hear from the community on this. Before you speak, you'll have to key up the mic, and then please state where you're from, your name and where you're from. Thank you.
Thank you, Justice Wilson. My name's Diana Scott. I'm at 299 North Platinum in Fayetteville. 3 minutes, 3 topics. Tonight, you're going to be taking up J.P. Koger's resolution in support of the Northwest Arkansas Community Corrections Center, in support of continuing it. And I really want to encourage you to do that. I know it doesn't have legal binding, but I believe this quorum court does have some sway in these matters at the state level. I think it's an important statement to make. Secondly, what's commonly called the SCAP program, where you're accepting money from the Department of Justice for the State Criminal Alien Assistance Program. That program is very disturbing to me. It seems like it targets certain people in our community unfairly, creates a great deal of panic and fear among our citizenry, and it is, from my understanding, a voluntary program. So I don't know why we're volunteering for that, but point 3. There is a lawsuit that's been brought to you from the Arkansas Justice Reform Coalition. And I'm not arguing the point of that lawsuit this evening. However, it's my understanding that the Quorum Court is going to be asking taxpayers to foot $100,000 in extra funding to litigate that case. And my concern is that the people on our staff who would address this are already earning a very good living. I don't know where an extra $100,000 is necessary for doing their job. Thank you.
Thank you. More citizen comments? Please state your name and where you are from.
Yes. My name is Jeannie Bergen, and I live in southeast Fayetteville. And I serve on the board of directors for the nonprofit Ladies of Grace. We are a volunteer organization that goes into the ACC Women's Prison and provides numerous services for the women incarcerated there at no expense to the state or county. We have the privilege to see the lives of residents changed as they experience dignity and hope for their future. I want to share with you 2 events that Ladies of Grace have been a part of at the facility. The first one is Unify the Family, an event that we had at a local church where the women were allowed under supervision to leave the facility and be reunited with their children for a day of carnival games, complete with bounce houses and all the activities, face painting that children love. It was a beautiful day with much fun, laughter, and tears. The residents were able to play with their children and experience a day of normalcy, which gave them hope to be the mothers their children need. One resident told us, quote, "Just knowing people cared helped me to be more serious about recovery and working the program." That's from a resident who attended that day. The second event is the Christmas Photo Day. In partnership with a local church, we were able to provide a professional photo shoot where each woman received 4 beautiful photos of themselves to send to their families for Christmas. Ladies of Grace provided them with white shirts and makeup for each woman, and they spent the morning getting ready for their photos. As they came in for the pictures, we could see that for the first time in a long time, they felt beautiful. One resident shared that her mother said, quote, "I got my daughter back. I thought I had lost her forever to drugs." We truly see life change taking place at this facility. It has the lowest rate of return than any other facility in the state. It would be real tragedy to close a facility that has been seen so much success. There must be another solution to the overcrowding at the Washington County Jail. Please do not allow this successful model to be shut down. And as I close, I want to share one more thought with you. You, as the Quorum Court, are a steward of the resources of Washington County, financial resources, natural resources, and the unique contributions of the county's human resources and potential. In the several nonprofits that serve at the prison, over 350 individuals, we have a unique set of gifted people that serve the needs of the residents at no cost to the county or the state.
We are out of time. Or were you on your last sentence?
Can I say my last sentence?
Please.
The resource is a gift to the entire state of Arkansas that our county is uniquely positioned to offer. It is not replaceable.
Thank you. Please state your name for us and where you're from.
I'm Catherine Gates. I'm from Fayetteville, and I have been serving in the Community Corrections Facility as a volunteer of Ladies of Grace for 10 years. I'll never forget the first time I went in to teach the women in the facility. I prepared a message to help them understand that their work matters to God. That's the work that I do for working people, to integrate their faith and work. And I had no idea how they would receive that message. These women were quoting scripture back to me. I left feeling energized, even though I had poured into them and prepared that message. I fell in love with those precious ladies that night, and I haven't stopped serving ever since. One night, I used Bible storytelling to share the story of the 10 lepers that were healed by Jesus. And when we broke up into small groups, and afterwards, the leaders were coming back to tell me that the ladies were saying they saw themselves in this story, and they realized that their addiction was their leprosy. It's amazing to see how engaged these women are, how much they want to learn and grow and really lead productive lives and break the cycle of dysfunction and addiction and the brokenness that they've experienced. Some have expressed even gratitude for bringing God to this place because they knew that they would be able to heal and recover there. They feel seen and loved and heard in that place, like no place else that they could go. I've seen women come out of this program and go on to start ministries of their own to help other women who have gone through the same experience or going through the same experiences so they don't have to end up in incarceration. Their mission is to help other women see that they don't have to go that same path. The women have shared with us that they feel seen and loved for the first time. They've commented on how we treat them the way they see us treat one another. They actually have an example that they've never had before of people who really see their value. We see women literally being transformed, praising God, reading God's word, and praying with and for one another. These women need to know that they matter, that someone cares about them. They need to see examples of what a new, productive life can look like because they haven't. They're not only changing their own lives, but they're changing the lives of their children and all of those they influence. I pray that all those involved in this decision will seek guidance and provision from God in this matter so that these women can break these damaging cycles, thrive, and influence others to lead productive lives.
Thank you. Please state your name and where you're from.
I'm Laura Marsh, and I live at 1834 North Independence Place in Fayetteville, and I'm also a Ladies of Grace volunteer. So first of all, I want to thank you all for indulging us. I know I've talked to Brian and Charles and Suki and others just sharing the stories about what happens in this prison. And I think it's so important just to be able to put the human face on what's really happening. I'm just going to share one other quick story that comes to mind. There was a lady that was in my small group, and she had made the comment that she had started using drugs when she was about 13 with her mother. She knew she was hell-bent on destruction. And so at that point, she just decided to just binge and just let the Lord take her life. She ended up in the prison. And, you know, as she said, this is the best thing that's ever happened to me. She said, I checked out rehab programs. Most rehab programs are full. You have to wait for months. They last 2 weeks. She said, I'm in here for 11 months. This is the best thing that could have ever happened to me. And so one of the things that I think is so amazing about the prison and just this whole, the journey, is we've gotten to share with you all and just the community and the state exactly what's going on in this unit. Otherwise, people wouldn't have known. I do think we have more attention right now. We've got some state senators and state representatives who are real interested right now in trying to get in front of the governor and trying to secure funding on a long-term basis. I don't know if it's going to happen this week and next month, but I do think that some of that's in the works. People are interested, and because this is something that people want. And so we at Ladies of Grace, we understand that there's overcrowding in the Washington County Jail, and that's a problem. And I'm going to say that, you know, going forward, we probably need a bigger jail. We're a growing area. We had a vote on that several years ago, and we voted no as a community. And in fact, I voted no, not because I didn't want a bigger jail, but because I want to see things going on in our jail like are what are going on in the Women's Center. We want life change, because just throwing these women in and telling them to suck it up and get their life together is not going to work. So we've got actual programs going on, just pulling up roots, changing lives, changing families, educating women, helping them get job certificates, getting them job ready, making sure they've got support so that when they go home, the cycle doesn't repeat. So what I want to leave you all with is, of course, I hope you all will sign on to the proposal tonight. But going forth, this is what we want in a new jail. This is what we want. We want changes. We want reforms. And I think if you all will do that next time, I think we will get that bigger jail.
Thank you for
so
your
much.
comments. Appreciate that. How much time we got? No, we're not done yet. We have time for you if you want to make some comments within 3 minutes.
Do I have to do anything here, or is it done? Because I'm so short, I know. My name is Rosie Presley, and I live at the top of Cleveland Hill in Fayetteville. Have lived there for 30 years, have been in Fayetteville for over 50 years. I'm old. And I'm president and educational director of Ladies of Grace. We are a bunch of women, church ladies, who got together and created a nonprofit because we felt there was a mission to go in to the prisons and be with the women who are incarcerated. Our founder, Rita Ivy, who's here tonight, she came in late, she got stuck in traffic. But she said the first time that she went in, which was shortly after this center opened, she said that she asked the women, what do you need? What would you want a group of women to bring in? And the first woman said, can you teach us to be ladies? And so that became our name, Ladies of Grace. And that's what we do. We go in, we teach life skills from a biblical perspective. We help them develop character. The women are young and we're old. A lot of what we do is we help reparent them. They've had problems with their family forever. I'd say close to 98%. We've taken polls with all the different groups that come in. Most of them are addicts, alcoholics. They've been alienated from their families for a long time. And as you've heard tonight, some of the activities that we've been involved with them, part of what we do is help them get back on track so that they can reunite with their families. I've sat with groups of women, and each woman would tell me where their children were with an ex-mother-in-law. Some of them were, some of them were wards of the state. But their deepest desire, once they sober up, is to get back with their families. And they don't know how to do that. A lot of them, as you heard before, first time they did drugs, it was with their mother or their father. So they haven't been parented. And that's what we bring in a lot of the time. In my normal life, I'm a licensed professional counselor. I've been in practice for 30 years in Fayetteville. In fact, I retired June 1. So I'm no longer doing that. But I've been with Ladies of Grace for over 10 years. And it's been the best thing that I think I've ever done. The joy that we receive from being with those women is boundless. It's a wonderful feeling. I know that we've looked at statistics, and it seems like they all come from this area, but we know they don't. But we do see them. We see a lot of them out in the community. And there's such joy when one of our girls will run up and say, do you remember me? I was in your class, and I'm doing good. What joy that brings to our hearts to hear that. And the volunteers receive that kind of joy, too. Just recently at a baptism, where 12 girls were baptized, one of our new volunteers said, wow, I think this is one of the top 5 events of my life, to see that many women. We love you. We know you have a hard job. And thanks for listening, because a lot of us are just venting. We don't want to see this go, and we're grieving, and we're sad. So we hold you to the right decision. Thank you.
Thank you for your comments. Thank you to everyone for coming this evening and for sharing of your perspective. And thank you for your involvement. We appreciate that. Next, of course, on our agenda is the approval of minutes. Those minutes, of course, were emailed out to members of the Quorum Court in the agenda packet. At this time, are there any corrections that need to be made? Seeing none, that they will be approved as they stand, and we won't need a motion necessarily or a vote on that, but they'll be approved. Next on our list is We begin our, well, it says County Judge's report. Of course, we know he isn't here. He did include some information in our packet to call to your attention for those of us on the court. But I won't pretend to speak for him and provide an update on anything. That's not my role here this evening. But you can see some of the information in the packet. The unfinished business is next on our agenda, and that's item number 8. Counselor, do you want to read that for us?
An ordinance amending Section 9 of the introduction section of Ordinance 2018-50, the Washington County Employee Handbook.
Thank you. J.P. Real Stafford, do you want to begin with any comments for this particular item?
Move to go to the third reading.
Okay, I hear a motion from J.P. Real Stafford that we move this to a third reading. Is that correct? And I hear a second from J.P. Dean. All those in favor, please say aye.
Aye.
All opposed? I hear one no. I only heard one dissenting vote at this juncture, so we will move it to a third reading. Counselor, would you do that, please?
An ordinance amending Section 9 of the introduction section of Ordinance 2018-50, the Washington County Employee Handbook.
Thank you. Again, I appreciate your patience very much. I'm moving papers and trying to master this microphone system all at the same time, but we will get through that. J.P. Real Stafford, did you have any comment as we begin our discussion this evening?
Yes. Before we moved forward with any motions on this, I wanted to, it's been a couple months since we first heard this in committee, and I wanted to queue up our Deputy County Attorney, Catherine Baker, to kind of recap this ordinance and what these changes are and what it would do. And give folks a chance to ask any questions first.
Very good.
Thank you, Justice Stafford. This policy is an update to reflect the current state law regarding workers' compensation insurance. The drug-free workplace policy is a program by which we can receive a 5% discount in our workers' comp insurance policy, which is offered and which we purchased from the AAC, the Association of Arkansas Counties. And they also wrote the template for this policy. So it's fully compliant with the law, fully compliant with our insurance carrier, and reflects the questions that I've received have been around 2 issues. The main one being that there is concern about pre-employment drug testing, that we're absolutely required by law to pre-employment drug test anyone who is who has a position that would be under the Department of Transportation, such as a CDL driver or anyone that drives passengers in a vehicle, and also, of course, law enforcement. They're considered safety sensitive, which is a phrase that's taken from the Arkansas Medical Marijuana Amendment. So anyone who's safety sensitive would be someone who carries a firearm, interacts with the public in that kind of law enforcement way, or, you know, again, they relist in that list driving a vehicle carrying passengers and other commercial vehicle types of positions. So out of all of this policy that we're advancing, the county does need to comply with the policy in order to provide the correct notice to applicants. That's a big legal liability for us if an applicant comes in to accept a position and is drug tested without notice. that can create some constitutional violations and other, personal liberty violations for that employee. So we have to get all our notices lined up. So whether we decide, we can decide to only pre-employment drug test the people for whom it's required by law in other areas of law. Again, safety sensitive or commercial driver's license, let's just say. The question before us is whether we're going to pre-employment drug test every type of person, such as a clerical person. I was not able to talk to our HR director today, but my understanding from the sheriff's office is they never get a positive drug test. We feel that it would be an efficiency for the county not to pre-employment test people for those clerical type positions, in that we're trying to attract the best employees that we can attract. And so those are the employees that are going to have several offers or several contemplated employers. If we create a barrier that adds a week before they can start their job and they have to drive somewhere, it's just an administrative burden. And then it costs the county something, to test every person, even if they're not in a position that requires this. Whatever we decide about pre-employment drug testing, every employee is subject to reasonable suspicion drug testing, all of the other drug testing implicated under the law. So that is one question we've received. We've also received a question about what are the exact rules for drug testing? How does it work? That's pretty much covered under the certification of the drug testing company. And part of our application to receive this 5% discount, which we have to submit every year, we have to submit paperwork to the state. Part of that application is to list the drug companies that we use and for what purpose. Are they DOT drug testing? Are they testing for the sheriff's department? And their certification carries all of that administrative burden of the exact rules, the step-by-step of what they have to follow. And then, of course, internally in HR, we'll have our step-by-step policy and procedure, just our internal administrative procedure of how that's all handled. And it's really spelled out pretty clearly in the law. We don't have much wiggle room there, but especially with the medical marijuana amendment coming on board. That's what has brought all of this again to the forefront, causing many companies and government agencies to take a look at their drug testing policy and see where we're at as far as the law even asks us and requires us to test minimally because there are constitutional protections in my personal rights as an employee to offer over a part of my body for drug testing, which is the way the law would look at it. So we do have certain constitutional protections that we have to offer our employees. The law encourages us to push that boundary as far as we legally feel responsible. We have the good fortune of being a large county with a large staff. We feel that we can handle this kind of administrative work. So we're not concerned that we would violate any portion of the law by adopting this policy as written. The policy also in the law and the way it's written here, it articulates the legal protections that are provided both to the employees and the employer by following this policy. We don't anticipate that adopting this policy, dropping pre-employment drug testing for those clerical type positions, we don't anticipate that that'll cause any change in our hiring practice, except that it'll remove that week or so of wait time for that employee to get their results back, have it processed through HR, and then begin employment. So we're looking at that section to just create administrative ease for us in the county and our HR department as they onboard people twice a week. It removes that administrative burden for that set of employees. And if anyone has any questions about the policy as anticipated, or if you have any thoughts or questions about potential amendments, I'm happy to answer those questions.
Thank you, Councilor Baker. I believe J.P. Lyons has keyed his mic up. You had something to say perhaps from earlier?
I have an amendment for this ordinance being passed around. So the amendment itself is basically to modify the proposed ordinance to require all applicants to be post-offer pre-employment tested. And it should, that what you're getting are the markups to that. I believe it is a good policy. We need this policy. Drug testing, according to who is this? The National Safety Counselor lowers employees' turnover, reduces workers' compensation costs, increases productivity, and lowers insurance expenses. I believe we should start that at the beginning of someone's employment with the county, not after. Not after we have invested within an employee for 3, 6, 12 plus months to then get required to do a drug test due to observation or whatever, and then having to remove that employee and remove them from their work because then they test positive. I know there's been some discussion around when you do that, it reduces your pool to hire from. I don't know. I don't believe that. I have not seen data to support that. Actually, based on even you read the ordinance that's here, if you are pre-tested, you test positive, and you have the medical marijuana card that would explain that, or medical prescription that would explain that, the county never knows. That is all adjudicated by someone outside of the county, and then when they see that, then it just comes back as, that's the reason, then the county just knows you passed, right? So there's no downfall to that. Therefore, I make a motion.
Okay. J.P. Lyons has made this in the form of a motion, correct?
Yes, sir.
And I heard a second from J.P. Lemming. Is there other discussion concerning the proposed amendment, which should be now in front of you? Okay, J.P. Real Stafford.
I just have a procedural question. Can we have a motion on an amendment before a motion on the main ordinance? Since we don't have a motion on the main ordinance yet.
I'm still trying to. Forgive me, we're trying to key his mic up.
It's the equipment, it's not you, David.
Yeah, so we can amend this ordinance even though there's not a motion on the floor to pass right now.
Okay.
So you can make, because we're amending the ordinance, and then we can, if it's amended, it can then be moved.
Great.
But I will state that if it is amended, it will go back to the first reading.
Okay.
Did you have other questions? That was the only one? Okay. J.P. Bowerman, I believe your mic is...
Yes, I was wondering if we have any data as to failed drug tests. We're requiring them now. If we have any data over the last year telling how many were failures before that they were hired.
I certainly can't speak to that. Councilor Baker, do you have some that you could share with us, or have you run across any particular data?
I'm not asking for names. I just wanted to know numbers.
I don't have numbers. I did not get that from HR today, but my understanding from previous conversations with the Sheriff's Department is that they don't have them. They don't have positive drug tests.
This is not giving me the option at the bottom. There you go. Okay. Who did I key up there? J.P. Koger?
Thank you very much. I guess my first question is to Attorney Baker. Is this amendment, do you see any legal issues or anything with this amendment as it's presented? I mean, as far as compliance and all?
I do not.
Okay, I was in a JSEP meeting a while back, and it came up, some of the department heads, elected officials were talking about how long the onboarding process was taking, and I thought that something was done that said that the prospective employee could go to work pending the test, but maybe this is what that is changing, but I'm not sure.
What this policy would change by removing pre-employment drug testing for non-safety sensitive, non-DOT applicants is that it would relieve the administrative burden from HR and the cost. But for the applicant, it can take 3 days, a week, it depends. I can give you an example from my personal experience. I was moving from out of the county to take the position, and there were many, it took, I don't know, a week and a half, 2 weeks, because the company would automatically schedule me for a test in Fayetteville. Well, that would require me to take 5 hours off of work. So it took several phone calls and iterations to get that process through. Not every employee is going to have that kind of burden, but it does create a time gap between the time that the employee would otherwise have been able to start employment and when they get the results, it's processed through HR. I'd also like to add that in that JSEP meeting, every elected official supported not drug testing, pre-employment drug testing those positions, just for clarity.
Okay, thank you very much.
JP Hires?
Thank you. I wanted to respond to JP Bowerman's question earlier. 2 months ago, I asked that exact same question here at a meeting of the HR director. I've still never gotten the answer. And so I wanted to know if we knew what the cost of the drug testing was to drug test everybody in the county, and what the fail rate was. And I was not given that information. And I'm still curious about that question, because whenever I've looked up data as far as what other government entities have done or other businesses have done, many of them have decided that the cost of the drug testing, anybody who wants a job and knows that there's going to be a drug test will stop doing drugs long enough to pass the test. So you don't have a lot of people passing or getting dinged on a drug test like that. So I asked that same question 2 months ago, and I just want to say I'm not doing drugs, but if I had 2 job offers and one said pee in my cup and the other one said you're hired because of your professional capabilities, guess which one I'm going to take? I'm going to take the one that's not asking me to pee in a cup, personally. Okay, that's all. Thank you.
JP Dennis?
Thank you. I'll confess that I'm just a little bit confused. I sure can. I can even scoot closer. I'm a little confused. Are we saying that we want to have it so that, because we talked about it a lot earlier, and we haven't talked about it since that time, but the way I understood it was that this was to put legal, if you had a legal medical marijuana, you could use it in certain departments of the county, but you can't use it in the road department or the sheriff's department. Did I understand it that way correct? Is that correct?
Yes, that's correct, and this policy will not change any of those facts.
Okay, thank you for clearing it up for me.
I would like to say one thing. The way you stated it, you said you can use it in certain departments. I believe it's more correct to say nobody can use it at work. I think what you meant to say, though, was...
No, that's not
what you
meant.
That's
not what I understood. I mean, you can take medical marijuana and not be quote-unquote using it at work.
I understand what you're saying, but the way you worded it sounds like we can use drugs at work, and that's not what anybody wants.
Okay,
that's not what anybody's proposing, I don't think.
Okay, now that you've asked me, then I didn't know a lot about it, so I went to someone that was a doctor in this field, and I asked them about it, and that doctor said if they're using medical marijuana, it's the same thing as using some other kind of pain medicine. They need to go home and they need to take sick pay and go home and get well and come back and not be using medical marijuana while they're have it in their system while they're working. So I'm a definite no on it, since this is the way it's worded, so, thank you.
Thank you. J.P. Lyons? Try it now.
I was just going to clarify that the point earlier, Counselor, was the Sheriff's Department has never had a positive, but the Sheriff's Department is also required to test pre-employment, correct? Okay, thank you.
J.P. Lemming? No, key that again. I think I accidentally shut you down. That was not my intention.
I just want to make a couple of points. As a business owner, the question you're asking about data on drug testing, that drug testing policy for business owners is very touchy. And for the county, the county ain't going to track. It's illegal. They'd be in a lot of lawsuits. They can't do that. And the medical marijuana, like you're talking about, if you're a CDL truck driver, it's federal law. You can't have medical marijuana. You can, but you can't have a CDL driver's license no more. So they're protected under the DOT department on some of that stuff. A lot of the employees that I've talked to in the county, they say if I got to do it, everybody needs to do it. And I have no problem with that. I don't care if you're an attorney. I don't care if you're the judge. I don't care if you're Willie Lemming a JP. If they want me to pee in a cup, get it out. I'll do it. I think it's fair for everybody. It costs us 30, 40, 50 bucks. So be it. Be fair with everybody and be the same. That's the way it needs to be. And the sheriff ain't going to have no problems because, just like Suki said, if you apply for a job and they're going to drug test you, you're not going to be crazy. When I worked for the highway department, the first time I was ever drug tested, the lady come from Little Rock, pulled in one morning. We walked in the bathroom together, and I peed in the cup for her. That's the way it ought to be. That's fine. That's the way employers ought to treat it. It's fine that way, and I think we ought to do that. It's no big deal. And if the medical marijuana, the way I heard Miss Catherine tell me a month ago when I talked to her, was they look at medical marijuana just like a heart pill. I take a heart pill every day. You can take medical marijuana. You say you can't do it on the job. I take a heart pill every day and go to work. You can do that. You can do medical. Is that right, Catherine, or is that wrong?
Wrong.
Okay, what's wrong about that?
Do I have the floor? I think there's a misunderstanding about the constitutional amendment for medical marijuana. What that amendment has done is created a carve-out in the law for people who
created problems.
For people who have gotten a license to purchase marijuana legally in the state of Arkansas, and employers are not allowed to discriminate against that employee. That being said, that employee is not eligible to participate in a CDL license, a safety-sensitive position. There are certain, for an employee to participate in the medical marijuana provisions, they're eliminating themselves, they're removing themselves from certain job pools, and that's just the fact. But the employer, by law, is not allowed to discriminate against that person. So this is, for a person to have a medical marijuana license, it is a permission for the government for that person to purchase marijuana at a dispensary in Arkansas. It's not a prescription. It's not a medical event. And so to say that using marijuana is like taking a heart pill is something I would never say, and it's not true. And to say that a person who wants to enjoy marijuana during the day can just say, I need to take off because I need my pain medication, that is not true, and that is not what the law states. That's not the type of protection that's given to a medical marijuana patient. A medical marijuana patient is given the protection that when they come in and take a pre-employment drug screen and test positive for marijuana and submit their marijuana license to the testing agency, that's considered an approved drug test result. And so the employer then would not be notified that that person had tested positive for marijuana because they have a medical marijuana license. And so pre-employment drug testing will do nothing to eliminate potential employees who have a medical marijuana license. So if anyone thinks that that's what this will accomplish, there is no situation in which this will accomplish that, because that's against the law.
Thank you for clarifying this stuff, but I still say all employees need to be drug tested. Thank you.
J.P. Washington?
Thank you. I don't know that I have any additional comments because she just said everything that I was going to say. I just really wish that we wouldn't conflate the issues. This ordinance is about post-offer pre-employment testing, and so let's keep that in mind. And so I would also like to note, and I believe that J.P. Hires has said that when we first discussed this months ago, that all of the elected officials were in favor of the original ordinance. So I would encourage us to vote no on the amendment and to support the original ordinance. And with that being said, I call for the question.
Okay, if you call for the question, then we need to vote. In all fairness, though, J.P. Ecke had asked to be recognized before then. Okay. Okay. It's a good thing the counselor's beside me. I wanted to go by the rule. The call for the question, we will have a voice vote on. Do we have a second to call for the question? Second by J.P. Hires. The original motion, I believe, was provided by J.P. Washington. So we will have a roll call vote on whether or not to accept the amendment that we've been discussing.
Call the question, to end debate.
Okay.
The motion on the floor is to end debate and call the question. That's what
Okay.
we're voting on.
We're going to vote on whether we end the debate. A yes vote will be that we cease the debate on the amendment. A no vote means that we can continue the debate. Okay? Mr. Allen, would you do the roll call?
Justice Simons? No. Justice Bowerman? No. Justice Lyons? No. Justice Ecke? Yes. Justice Dean? Yes. Justice Washington? Yes. Justice Coger? Yes. Justice Dennis? Yes. Justice Hires? Yes. Justice Rios Stafford? Yes. Justice Lemming? No. Justice Ricker? Yes. Justice Pond? Yes. Justice Taylor? Yes. Justice Wilson?
No.
No.
The motion passes. Debate has ended, so we are back to the original discussion on the motion to amend, yes.
There's no discussion. We've ended that. So we've had a motion to amend by Kyle Lyons and a second by Willie Lemon. We need to vote on that now. Yep, on the amendment itself. Yep.
Okay, do I need to restate the motion?
Yes, I would say, the motion to amend by Justice Lyons, a second by Justice Lemming.
The motion to amend this ordinance was made by J.P. Lyons. It was seconded by J.P. Lemming. And now we will vote on that, and I ask if Mr. Allen would please call the roll on the amendment. A yes vote is in favor of the amendment.
Justice Simons? Yes. Justice Bowerman? Yes. Justice Lyons? Yes. Justice Ecke? Yes. Justice Dean? Yes. Justice Washington? No. Justice Coger? No. Justice Dennis? Abstain. Justice Hires? No. Justice Rios Stafford? No. Justice Lemming? Yes. Justice Ricker? Yes. Justice Pond? Yes. Justice Taylor? Yes. Justice Wilson?
Yes.
Yes.
The motion passes for the amendment.
So we're back on the first reading, so we need to read it again.
At this point, the counselor will read the ordinance again.
An ordinance amending Section 9 of the introduction section of Ordinance 2018-50, the Washington County Employee Handbook, and this is back on its first reading. Now, right, as amended, yep, so we can now, you can ask if any, I think there's some people raise their hand. If it doesn't move to a second reading, then it'll move to a second reading at the next meeting. So we're ready for a motion. Well, yeah, I would see if there's, you got some people with their hands up.
J.P. Rio Stafford.
Thank you. Move to suspend the rules and go to the second reading?
Okay, I have a motion by J.P. Rio Stafford to move to the second reading. I have a second by J.P. Lyons. Is that correct? All those in favor, please say aye. Aye. All opposed? It moves to the second reading.
An ordinance amending Section 9 of the introduction section of Ordinance 2018-50, the Washington County Employee Handbook.
J.P. Pond.
Move to suspend the rules and put this on the third reading.
Okay, I have a motion by J.P. Pond to suspend the rules and move to a third reading. I have a second on that motion from J.P. Lyons. All in favor, please say aye. Aye. All opposed? That motion carries.
An ordinance amending Section 9 of the introduction section of Ordinance 2018-50, the Washington County Employee Handbook.
J.P. Lyons.
Make a motion, we suspend the rules and move to the third and final reading.
We just did that. We just did that. Now it'll be a motion to pass.
Oh, I'm sorry. Motion, I thought we did second. Okay, I'm lost. Motion to pass the ordinance.
I have a motion by J.P. Lyons to pass the ordinance. I heard a second originally from J.P. Bowerman.
Any discussion?
Is there any discussion at this point? Seeing none, we will now open this up to public comment. Are there any public comments that need to be made on this particular issue? Okay, seeing none, we will have a roll call vote on this particular ordinance. And I ask if Mr. Allen would please call the roll.
Justice Simons. Yes, sir. Yes. Justice Bowerman. Aye. Yes. Justice Lyons. Yes, sir. Yes. Justice Ecke. Yes. Yes. Justice Dean. Yes, sir. Yes. Justice Washington.
No.
No. Justice Koger. No. No. Justice Dennis. No. No. Justice Hires.
Yes.
Yes. Justice Rio Stafford.
Yes.
Yes. Justice Lemming. Justice Ricker.
Yes.
Yes. Justice Pond.
Yes.
Yes. Justice Taylor.
Yes.
Yes. Justice Wilson.
Yes.
Yes.
The motion passes. That will take us to the consent agenda. And as stated earlier, the last item on this consent agenda was removed. All the others do remain. Motion.
No, I'll read it by title only.
Councilor Lester will read by title only.
Item 9.1 is an ordinance recognizing and appropriating additional revenue in the amount of $228,407.06 in the Animal Shelter Projects Fund budget for 2024. Item 9.2 is an ordinance creating the position of Commissioner of Public Buildings in the ARPA Fund budget for 2024. Item 9.3 is an ordinance amending Ordinance 2024-10. Item 9.4 is an ordinance amending the jail budget for 2024 and further matters pertaining thereto. Item 9.5 is an ordinance anticipating and appropriating revenues in the amount of $1,081,999.92 in the Crisis Stabilization Unit Grant Fund for 2024. And item 9.6 is an ordinance anticipating and appropriating additional grant revenue in the Drug Court Grant Fund for 2024. We need to make a comment real quick. Okay. And I want to point out, all of you were given a sheet of paper with some yellow on it. Treasurer Hill, he was out and he was absent when we were putting the ordinances together and didn't get a chance to comment because he was out. He got back and he made a comment. The ARPA money needs to come out of the ARPA fund and not the county judge's fund, not the county judge's budget. And so what you have in the packet is amended. We'll need a motion to amend, but as you can see, I've highlighted in yellow what we had. And all we're doing, we changed from the ARPA fund, which changed the position number, and it also changed the amounts. There was also realized an error. The workman's compensation was left out, I believe. And so and there was an error in another calculation. So basically what we've done is changed this to coming out of the ARPA fund for tracking purposes. So it's easier for us to track those and get that information to the government because we have to tell them what we're doing with this ARPA money. So we'll need got a motion to amend.
We have J.P. Dean making a motion to amend based upon what the counselor just shared. Do I have a second? Have a second from J.P. Ecke.
Any discussion? Yeah.
At this time, we open the floor to discussion on this particular issue. J.P. Lemming.
Thank you. Brian, do we have any kind of ideal when the project's going to start and when we will need this employee to start? Or is there a reason to go ahead and get it on board now?
So the EOC, the project has started. We haven't done any dirt work, but the actual design of the project has begun. And so this person we'd need to get this person hired pretty quickly because they're really there to oversee the actual groundwork and the actual construction.
So
but I don't know exactly how long.
I'd say there's money being spent out of that account, so therefore he needs to be on board with it.
Correct.
Okay, thank you.
J.P. Koger.
Yes, thank you. Attorney Lester, could you repeat what you said at the last about why it was coming from ARPA? Then you said something, and I didn't hear all of it, but something about ARPA regulations. What did you say about that? I didn't hear you.
So the ARPA money has to be tracked. It's like a grant. You have to track that money. Unlike the general fund money, we don't track. We don't provide that information to anybody. But the ARPA funding money is tracked. And we do return or give reports back to the Treasury about the use of the ARPA funding. And so because this is ARPA, an ARPA position and ARPA funded, it needs to come out of the ARPA budget. Instead of us taking it, it could be done out of the county judges. We'd take ARPA money, we put it in the county judge's budget, then we'd have to go in and track all that through the county judge's budget to send back. So Bobby Hill has suggested, and we have always done, based on his suggestions with the ARPA funding, that we spend out of the ARPA budget and not put it into other budgets because it's easier for us to provide those reports and tracking information to the government instead of having to do kind of like a double duty on tracking all that down and pulling it out.
Okay, thank you for that clarification.
You're welcome.
Other comments or questions at this time? Other discussion? We can vote on the entire consent agenda.
No, we need to vote on the motion to amend. Second by Lisa Heck. We need to vote on the motion to amend.
Okay. We have a motion to amend, and we have a second already by, was it J.P. Ecke? We need to vote on that particular amendment.
Point of order. I'm sorry, but
What is your point of order?
I'm sorry, but just to be clear, when Mr. Lester was reading the ordinances by title only, I think he read the animal shelter one, and that was pulled from this consent. He didn't? No. Okay, I'm sorry. Go ahead.
We need to do a roll call vote on the amendment.
Nope. We're only going to be voting on the motion to amend at this point. You don't need a roll call vote.
All those in favor of the amendment, please say aye. Aye. All opposed? The amendment passes.
Now we need a motion.
Is that the entire consent agenda? Okay. I have a motion from J.P. Ecke to approve the consent agenda. I have a second from J.P. Dean. Any additional discussion at this point? Okay. Are there public comments concerning the consent agenda, please come to the microphone. Just one second, please. I haven't keyed you up, but I'm going to do that. Yes, please begin again.
Sherry Main, 15451 Riches Road, Fayetteville. I just want to comment on one of the items on the consent agenda, actually two, but I'll start with the $100,000 or $50,000 for the Commissioner of Public Buildings. If we're going to change that from the unappropriated reserves in the ARPA fund and not appropriate it to line items in the county judge's budget, we need to back up and correct the other part of the ordinance, which is Article 1, and the position is going to be created in grade 11 in the county judge's budget. So does that need to be corrected to follow along with it coming from the ARPA? Because we're not taking it from the
you can ask questions, but
okay,
we're not
I'm
required
just
to
making a
provide an answer.
comment that, in my opinion, I think we need to back up and correct that one as well, because this money is not being appropriated to the county judge's budget. So therefore, we shouldn't spend it out of the county judge's budget. It should come from the unappropriated reserves in the ARPA fund. So Article 1 needs to say the same thing in the unappropriated reserves of the ARPA fund, not the judge's budget. That's my first comment on this. And the second comment I have is, if we need a public building commissioner, I think we need a public building commissioner full-time, not just to oversee the ARPA building going on. There's a lot of other building, there's a lot of other refurbishments, and we have the word Washington County is erecting a public building and refurbishing an existing public building in the near future. Okay, that may not be related to ARPA. So in this ordinance, we're tying everything with the ARPA funds, and I think it's just going to be unclear if we need this position in the future or as a year-round position. It needs to be addressed here rather than to let this go on and then have to come back and amend it later. And then it will have to be amended anyway because the building is going to go on, and this money has to be appropriated for next year, 2025, before January 31st, 2024. According to the ARPA rules, it has to be appropriated. So we need to all do it at once. It's going to take longer than 6 months to finish this building project, and we know we're going to need the planning commissioner in 2025 as well. And if the money's not allocated by December 31st, we can't allocate it. That's the time limit, so.
Thank you for your comment. Is there any other public comments at this time? Thank you. Seeing none, we will do a roll call vote on the consent agenda. Mr. Allen, would you please begin the roll call?
Justice Simons. Yes. Justice Bowerman. Yes. Justice Lyons. Yes. Justice Ecke. Yes. Justice Dean. Yes. Justice Washington. Yes. Justice Koger. Yes. Justice Dennis. Yes. Justice Hires. Yes. Justice Rios Stafford. Yes. Justice Lemming. Yes. Justice Ricker. Yes. Justice Pond. Yes. Justice Taylor. Yes. Justice Wilson.
Yes.
Yes.
The motion passes. 9.7 is the next item on our agenda. Counselor, would you please read that?
Item 9.7 is an ordinance amending the animal shelter budget for 2024 and other matters pertaining thereto.
J.P. Ecke.
Thank you, Mr. Chairman. I'd like to make a motion that we pass item 9.7. We had full discussion in county services meeting. Thank you.
Okay, I have a motion by J.P. Ecke. I heard a second originally from J.P. Dean. Any discussion or question at this point? J.P. Koger, please key your mic again. It left the screen.
Okay.
Go ahead.
Thank you. I support this ordinance 100%. The reason I removed it from the consent agenda is I didn't realize that we could have a discussion about it if it stayed on the consent agenda. But I had some questions that I submitted that I've been trying to get answers to, and no one responded. So that's why I wanted to ask this tonight. The county policy manual says the first step in determining the value of a position is to complete a position analysis questionnaire, or a PAQ. These are new positions that we're creating in the animal shelter. So the policy manual says that's to ensure the consistency by rating each position on the same 15-factor job rating approach. So was that done in this case? And if not, why? And isn't it required to be done?
Yeah, so that was, if you read the Article 1 of the ordinance, you'll see that those were given a grade 4 in the animal shelter, and that was based on the grading of the grading system.
But who made that decision for the grade 4? It didn't go through JSAP.
Oh, it went through the HR who does the grading.
But it's always been my understanding with JSAP that any new positions have to be approved through JSAP. Are you
No.
saying that's not true?
That's not true. As a matter of fact, as we've discussed in litigation, no one can seem to find anything that even creates JSAP. So that is not true, you're correct. But this was graded through our grading system, and that was the grade that it received. Because the county stopped using the old grade system, which was the Johansson group, and uses a different one when it passed the new salaries with the last budget.
Well, it just seems in conflict with what the policy manual says. That's why I was asking for clarification, and the judge never responded. So that's why I removed it from the agenda, from the consent agenda. And also, I'm not. I think this wage that we're paying, the $15.63 or $16 whatever, that's not a livable wage. And so I'm not going to make an amendment to change that tonight or anything. But I just want to point out that we're going to be starting our budget process very soon here. And I think that we should be thinking about our county employees and put them first when we start the budget process this year. This situation just brings that to mind. So the overall salary budgetary control, I would like for us to keep this in mind. So when we do start the budget process, which some people may already be working on, we can put employees first. Thank you.
Thank you. Are there other comments at this time? Are there public comments on this issue? Thank you. If you would press the microphone.
Thank you. Mac Mayfield, 980 Rocky Lane in Fayetteville. My understanding, and I don't know as much as a lot of you do, but my understanding is that this is a position that was filled by the ladies from the Correction Center, from the Community Correction Center. I find it odd that there is no feasibility study being conducted for the closing of that center. This is an obvious impact on the budget because those people won't be here. How we can proceed to say that we can do 2 jails instead of 1 without looking at the financial implications of that is beyond me. Thank you.
Thank you for your comment. Anyone else at this time? Seeing none, do we have a motion to pass? Have a motion to pass from J.P. Ecke. We have a second from J.P. Dean. Mr. Allen, would you please call the roll?
Justice Simons? Yes. Justice Bowerman? Yes. Justice Lyons? Yes. Justice Ecke? Yes. Justice Dean? Yes. Justice Washington? Yes. Justice Koger? Yes. Justice Dennis? Yes. Justice Hires? Yes. Justice Rio Stafford? Yes. Justice Lemming? Yes. Justice Ricker? Yes. Justice Pond? Yes. Justice Taylor? Yes. Justice Wilson?
Yes.
Yes.
Thank you. That motion does pass, or that ordinance does pass, and that brings us to item number 10 on new business on our agenda. Counselor, would you read that, please, by title?
A resolution in support of the Northwest Arkansas Community Correction Center.
J.P. Koger, would you like to speak to this?
Key up again. Key up again.
Okay.
No, push the button.
Hello?
Oh, good, sorry. The buttons are so close over here. Hit it
So
again.
push it again?
Yep. There you go.
Hello, hello. Okay, first of all, I want to thank everybody who came out tonight and earlier this month to speak about our wonderful Northwest Arkansas Correctional Center here for women. Thank you all for being here. Thank you for coming. Thank you for speaking up. So we've heard tonight and we heard earlier this month from community members, our constituents who came and pleaded with us, who are here tonight pleading with us to keep the CCC open, to not cancel the lease. That's because they realize what an asset to our community the center is and how it helps women break the cycles of incarceration. This center has over 350 volunteers from 24 different groups. And that's huge. I don't think you're going to find anywhere else where you have that much involvement with the community. If we evict the Department of Corrections and this center closes, it will be devastating to our community because we will lose a wonderful community partner and all his dedicated volunteers, and the people who are benefiting from the services of the volunteers will suffer. I agree that the Department of Corrections should pay fair market rent. And from my conversations with the people at the Department of Corrections, I think they're willing to do that, but it's going to be on the agenda for their June Board of Directions meeting. The judge is asking for $3.2 million, and I don't believe that's a fair market rate. He's basing the rent on what it costs to house someone in our county jail. It's really hard to put a dollar amount, though, on the good that the center does and the money it saves us by helping women break their incarceration cycle. I don't know how to put a dollar figure on that. There's probably people at the university, data analysts, who can do that, but I don't know how. But think about the women who receive the treatment there, and they don't recycle through the jail. Women who, with the help of trained staff and volunteers, are able to leave the center, get their children back, go find employment, and support their families, and in turn, help other women. So the $3.2 million should be offset by some amount to account for that. And we, as overseers of taxpayer dollars, should be leading the charge on that. The $3.2 million that Judge says the center cost us should also be adjusted to account for what it will cost taxpayers to operate and house prisoners in a satellite jail. If you think our current jail maintenance and jail operations and sheriff budget of $40.8 million, which is over 1/3 of our entire Washington County budget for this year, is a lot of money, wait until you find out how much it costs to operate that jail and a satellite jail. Especially if the state retaliates by removing some or all of the 309s from the detention center, which we've already seen the problem with the animal shelter. So I know this is a non-binding resolution, but we pass non-binding resolutions all the time. I think this resolution sends a strong message to the governor and to the Department of Corrections and to our legislators. I think that by passing this particular resolution, it will help us keep the center here and operating. And it would let our elected officials and the people at Department of Corrections know that we want them to all work together to negotiate and find a solution that will make that happen, because so many people need it to happen. Motion to pass.
Okay, I have a motion to pass this ordinance by J.P. Koger. Do I hear a second? Second. A second by J.P. Hires, is that correct? J.P. Ecke? Please key up again.
Thank you, Mr. Chair. I would like to thank the Ladies of Grace for being here this evening and speaking from their heart, and also giving testimony of changed lives. It is so impactful, and the work that y'all are doing is to be commended, and I commend you. And so thank you for being here. I commend Justice Koger for coming up with this resolution. However, I'd like to make a motion to send it back to committee to better reflect the language, to better reflect what the Ladies of Grace and the other nonprofits are doing, and to better reflect, just make some amendments upon hearing the testimony of all those nonprofits that came to committee services. This is already written before that, and hearing that, I would like to send this back to committee to make a few amendments and that really reflects these ladies and men that are doing this work. So that's my motion.
Okay, I have a motion to move this item back to committee. Do I hear a second? A second, but from J.P. Dean. Is there discussion on the motion to move it back to committee? J.P. Simons?
Thank you, Chair. I missed when the legislation is going to have this come up in committee and question if tabling this to taking it back to committee and bringing it back is prudent as far as a timetable of missing our opportunity to make this statement prior to our legislators considering this in their session.
So you're questioning the timeliness of it? Did you have other comments this time? Okay, thank you. J.P. Hires?
I'd like to echo what J.P. Simons just said, because that was my exact question. My understanding was we need to get this is very time sensitive. Pushing it back to refine the language in committee. When we're all here, we are the committee. If we need to refine the language, let's do it right here. Let's do it right now while the people are here, so that we're not wasting time, and get this in front of the people who are the decision makers in this particular sense. Thank you.
Thank you. J.P. Koger?
Thank you very much. This resolution, we talked about it last time, it was amended and it passed out of committee. It will make a difference if we postpone it. I have been told by Donna Tyler, who's Director of Communications at the Arkansas Department of Corrections, and by Lindsay Wallace, who is the Secretary of the Department of Corrections, or the Director of the Department of Corrections, that this issue will be on the June agenda. Now, I've asked several times what date that's going to be in June, and I have not heard back. I asked again today, but they told me it will be on the June board meeting. So it's very important that we pass this tonight. People have altered their lives to come out here now like 2 times and talk to us and tell us this, how important it is. We've heard from our community. We need to listen to our community. Thank you.
J.P. Ecke?
Thank you, Judge, or Mr. Chairman. Maybe I'm speaking prophetically, who knows? It's precisely the reason that the community came out here and spoke that I'm asking for this to go back to committee, that it better reflect our community and their words and their voices be written on the whereas, where as it's written, it's not. And I have been quoted as saying things, and there's no verification that, we'll just give it the benefit of the doubt, that she spoke with those people and that it will be put on the June agenda, but it's not verified. So until you have any verification, it's just, you can say whatever you want to say. But I would really like for this resolution to reflect what the community has said and what they've spoken. And that's why I want it to go back. Excuse me, I'm hearing some conversations being picked up in the mic. I'm sorry. For it to better reflect the voice of the nonprofits like Ladies of Grace to be put in there. And I think that will be more impactful than what's in there right now, because it doesn't reflect our community. So I appreciate your support in this, and thank you.
J.P. Koger?
Yes, I can, if, I can find verification on my phone with an email from Ms. Donna Tyler, but my phone doesn't operate inside here. But I can send it afterwards. We tried to use my phone before the committee started to find something, and we couldn't. But I have it in writing that it will be on the June agenda, and I don't know how else to prove that to you. And I want to point out again that this resolution we're looking at right now was amended last month, and the JP now who is wanting to postpone it is the one who made the amendment that we have before us. Thank you.
Other comments, questions concerning moving this item back to committee? We will have a roll call vote then. A yes vote means that the resolution will be moved back to committee for further consideration. A no vote means that it remains on the table this evening. Mr. Allen, would you please call roll?
Justice Simons? Yes. Justice Bowerman? No. Justice Lyons?
No, sir.
No. Justice Ecke? Yes. Justice Dean? Yes. Justice Washington? No. Justice Koger? No. Justice Dennis? No. Justice Hires? No. Justice Rio Stafford? No. Justice Lemming? No. Justice Ricker? No. Justice Pond? No. Justice Taylor? No. Justice Wilson?
Yes.
Yes.
The motion failed, so we are back to the original conversation concerning the resolution itself. J.P. Ecke?
Then I'd like to make a motion to amend the third whereas, line number 23. And actually it's line 24 where it says aligns with our Christian community values of sharing the gospel of Jesus Christ. And transforming lives as evident by the, the NWACCC nonprofit groups provide.
I have an amendment presented in the form of a motion by J.P. Ecke. I have a second
I'm sorry, and then one more thing. I apologize. I'm going through my notes. And I would also like the sponsor up there, the requested by J.P. Beth Koger to be removed and to put by the full quorum court. And you either can put everybody's name on there because this is a resolution by all of us. That's my amendment.
Okay. The counselor will restate the amendment at this time for purposes of clarity.
So I have the third whereas the services provided by the NWA CCC align with our Christian community's values of sharing the gospel of Jesus Christ and transforming lives as evidenced by the NWA CCC nonprofits. Are you wanting to continue with the of compassion, support, inclusivity? Or are you taking that, asking to remove that? Is that at the end of what you stated, or is it you asked? Oh, try again. This is.
No, I think that needs to stay in there because it does, that's what these groups do.
So let me restate that. Whereas the services provided by the NWA CCC align with our Christian community's values of sharing the gospel of Jesus Christ, transforming lives as evidenced by the NWA CCC nonprofits, compassion, support, and inclusivity, and contribute to the overall health and stability of the women incarcerated there and their families.
Thank you. I make a motion to amend.
So we have a motion to amend by J.P. Ecke.
And then also to put all our names on. Yes, sir. Okay, thank you.
And we have a second from J.P. Dean. Concerning the proposed amendment, is there further discussion? J.P. Koger?
Yes, I guess my concern is if we say align with our Christian community values, that we might be leaving out some other people. Otherwise, I'm okay with that amendment, but I don't think my name should be removed from it because I'm the one who wrote it and I brought it.
J.P. Washington?
Thank you. Excuse me. So, in listening to the proposed amendment, I believe that, let's see, I want to be very appropriate when I say this. I'm a Christian. Everybody knows that. And I believe that there are certain tenets that we believe in. We believe in compassion, we believe in kindness, we believe in inclusivity. However, there may be other people that subscribe to other religions that still support those same tenets. And I would hate to see a religion be weaponized to, I would just hate to see religion being weaponized in that way. I believe that the purpose of this is to show that we have the entire support of the whole community. And I believe that it is very unfair of us as a body to assume that only the people that are providing these services at the NWA ACC are only Christian. I know that we've heard a lot of the churches, we've heard a lot of them ministering the gospel, we've heard a lot of those things as well. But I believe that as a body, the message that we're trying to send here is that the Northwest Arkansas community as a whole supports this institution, not just those who are Christians, not just those who do whatever. And I just think that it would be very divisive for us as a body to do this. And once again, as someone who identifies as a Christian, so I hope that nobody twists this any other way, but I just believe that adding those words are unnecessary and they don't really augment or add to the message in this resolution.
Thank you, J.P. Washington. I'm going to say something at this point, not as the chair of the meeting, but as one of the 15 JPs. I did not want to do that and certainly not make a habit of it tonight while sitting in the chairman's seat, but it was made clear to me that in doing this evening, I did not relinquish the right to vote or the right to speak. So I will say this. I think that J.P. Washington has made some very good points. I think that J.P. Ecke has done the same. But I had some concerns with the language of this resolution myself. And at this point, I'm not speaking about whether or not we pass the resolution, because right now we are considering an amendment. And I wanted to say, for the good of the order, that when you look at the third paragraph, or the third whereas, that my colleague makes a very good point. J.P. Washington said that if you start adding a lot to it, then you run the risk of some things being misinterpreted, some being left out. And along those lines, when I first read this myself, I thought it would be better to never go down the road of talking about the community's values at this juncture in the document. You could simply say, and I'm not making an amendment now because that would be an amendment to an amendment, and I'm not asking that we go down that road, but I'm discussing the process of amending. It could simply state, whereas the services provided by the NWACCC contribute to the overall health and stability of the women incarcerated there and their families. If you don't mention any values at all, you never run the risk of saying this doesn't speak for all of us. You never run the risk of losing some support by not stating particular values. There's a lot more values in this county than has been mentioned here tonight. There's faith, family, hard work, Judeo-Christian work ethic. We could go on and on and on all night. We can't put them all in one document. And again, I'm not speaking as the chair, I'm speaking as a JP. And I wanted to mention that to be under consideration. I also want to say that one benefit of taking it back to committee would be to thoroughly hash it out and come to something that is a stronger wording and a better representation of everybody who is seated here, and certainly everybody in the county. I'm not proposing that either, but since I have the right to speak and any JP has the right to speak to this, that's what I was doing. I will also say that in past experiences, I've done a lot of writing myself, and anytime I write something, I can get it done pretty quick. But if a committee works with me, it'll take a week. And we're going to run into that here. That's just the simple logistics. And I hope we all understand that. So whether we solve all this here tonight or whether we did do it in a committee, it's going to take a little time, and it's some give and take. And I would urge all my colleagues to be a little patient if we're going to work through this process, no matter when it is. So those are my comments. I think, though, usually fewer words are better when you're writing anything. But at any rate, that's my comments, and we'll go on with further discussion at this point. We are still talking about the possibility of amending. J.P. Koger?
Yes, thank you. And I want to thank J.P. Washington for what she says. She said it much, much better than I did when I spoke. I also wish to amend my resolution to remove lines 23, 24, and 25 completely.
We already have a motion to amend, so we need to wait.
We have a motion to amend on the table, and it sounds like you're proposing a different amendment.
Well, there's been some controversy about amendment, so why don't I just remove? I'm moving to amend my resolution to remove completely lines 23, 24, and 25, and just go on from there.
And I appreciate you saying that, but we will have to take it up after we address the issue of the current amendment that's on the table. J.P. Ecke?
Thank you, Mr. Chairman. I don't know.
Parliamentary wise, I call a question.
You have to have the floor and be recognized. You don't have the floor.
I guess I'm not surprised that the name of Jesus Christ is referred to as a weapon. I'm not weaponizing anything. It's reflective of what the group did when they baptize the women. They baptize them in the name of the Father, Son, and the Holy Ghost. You're buried with Christ in baptism and raised to walk in newness of life. I believe that the nonprofits groups, everybody that testified on receiving communion. What is communion? It is a covenant, the body and the blood of Christ. So, Mr. Chairman, I'm not sure how this is being weaponized, if this is the very good news that the nonprofit groups like Ladies of Grace are using to change people's lives. Weaponizing is a pretty strong language, but of course, that's what the gospel says, doesn't it? So I'm just kind of dumbfounded that they would use a weapon in the name of Jesus, then say that it's a weapon being used. So, thank you.
Thank you. Next, the chair wants to recognize J.P. Hires, but if you would give me just a moment, I want to check something procedurally. Apologize for the delay. J.P. Hires?
Thank you, Chair. This is actually just a message to everybody who's here tonight that just wants a resolution passed. And I'm sorry that you've gotten caught up in some kind of ideological playground tonight. I don't care what language is in this. I'm going to get this passed so that we can get this to the state, so we can get on with the business that all of these people have come out here to do. So do what you need to the language to make you feel okay to pass it. Let's just get it done for these folks.
Thank you. Are there other comments at this time? Okay. J.P. Bowerman?
I'd like to call question.
Okay, the question has been called. We will have a roll call vote. A yes vote means that we accept the amendment that has been proposed by J.P. Ecke. A no vote will reject that amendment. Mr. Allen, please call the roll. Point is well taken. Forgive me. We'll have a roll call vote in support of calling the question. A yes vote means that we will call the question and have a vote, and then we'll proceed from there. A no vote means we can continue the debate. Who called a second on the call to question? Okay, thank you. Okay. Mr. Allen, would you please call the roll on calling the question?
Justice Simons? Yes, sir. Could you repeat that? Yes, sir. Yes. Justice Bowerman?
Aye.
Yes. Justice Lyons?
Yes, sir.
Yes. Justice Ecke? Yes. Yes. Justice Dean?
Yes, sir.
Yes. Justice Washington? Yes. Justice Koger? Yes. Yes. Justice Dennis? Yes. Yes. Justice Hires? Yes. Yes. Justice Rio Stafford? Yes. Yes. Justice Lemming? Yes. Justice Ricker? Yes, sir. Yes. Justice Pond? Yes. Yes. Justice Taylor? Yes. Yes. Justice Wilson?
Yes.
Yes.
It did pass, so we are back to the question of the amendment. We will have a roll call vote on that as well. A yes vote means you are in support of the proposed amendment. A no vote.
Point of order, which proposed amendment?
It is, and forgive me, I should have stated that J.P. Ecky's amendment is on the table. A yes vote would be in favor of that amendment.
Point of clarification.
Yes, sir. J.P. Simons, you might need to key your mic.
Thank you, Chair. After taking up this amendment, we will then take up J.P. Coger's amendment, correct?
I'm not sure she made an amendment yet.
Okay, thank you.
Thank you. So, well, for clarification purposes, let me say this for everyone in the room. J.P. Coger said she has made an amendment, but I instructed her that we would have to take that question up after dealing with the amendment on the table. So at this point, we will take up the question. A yes vote is in favor of the amendment by J.P. Ecky. And Mr. Allen, would you please call roll?
Justice Simons. Justice Bowerman. No. Justice Lyons. No. Justice Ecky.
Excuse me.
Yes, sir. Apologies. Justice Ecky. Yes. Justice Dean. Yes. Justice Coger. No. Justice Dennis. Yes. Justice Hires. No. Justice Rios Stafford. No. Justice Lemming. Yes. Justice Ricker. Yes. Justice Pond. Yes. Justice Taylor. No. Justice Wilson.
No.
No.
The motion passes. The resolution stands as amended. J.P. Ecky.
I'd like to make a motion to pass Resolution 2024 as amended.
J.P. Ecky makes a motion to pass this resolution as amended. Do I hear a second? Second. I hear a second from J.P. Hires. Is there a discussion? J.P. Pond?
Yes, thank you. Seeing as how this is a resolution, I can vote for it. I don't see it as any kind of a weapon. However, if this was an ordinance, I'd have to vote no. I don't believe we can legislate religion, and also I don't. From my reading and my studies, I don't believe Jesus Christ could support it as law. But I do want to express my gratitude to all the volunteers, everybody that has worked so hard in this facility. I do want to say that because people are listening, that there's some misinformation in some of the discussion and by some of the public comments. People have been misinformed. As far as, and I'm not even sure we should be discussing if this goes and is turned back to the jail, but as far as it being a satellite, it's just going to be the women's jail. And as far as staff goes, you have to have staff for the down there where they are now. You have to have staff for the women's part of the jail. Totally different from that of the men's, where they have to operate separately even though they're in the same building. So I feel kind of funny bringing that up, but it's been brought up when we're supposed to be trying to discuss a resolution that ought to be a positive thing. not a lot of fighting and negative statements should have been made. Had it been my resolution with the comments that have been made, I'd have pulled it. I just really would have been expressing my appreciation for what work has been done at this facility. Thank you.
Thank you. If I may, I will speak once more as a JP briefly. I'm not going to speak for everybody here, but I kind of sense that everybody on this quorum court is in favor of the spirit of this resolution. Now, if I'm wrong, I'll stand corrected, but that's my feeling, is that everybody appreciates the work that has been done in this location, appreciates everyone who's been involved, appreciates everyone for showing up tonight. I know I feel that in my heart. But you have seen an argument over some semantics, some wording. Some words are not as good as others, and I mentioned briefly just a moment ago that I had written things in the past, and in a former life as a school administrator, I wrote a short memo to the staff, and one of my colleagues said, "Let's let the English department take a look at this." And when they made all of their edits, I basically said, "This was good before you got a hold of it, but now look at it." And one of my colleagues went to my defense, and he kind of got on to the English teachers and said, "You don't have to stomp on this thing until it's a bloody mess." But I am sorry that the people who have come tonight have seen something that's almost turned into a bloody mess, and nobody here intended that. But I can vote in favor of it on behalf of the good folks who have made this a worthwhile project. But as far as the wording, I'm still not 100% satisfied, and maybe none of us are. But I just wanted to say that, again, as a JP and not as the chair. Are there other comments that need to be made at this time?
Call the question. Oh, don't do that, because we gotta vote on that. Stop. If nobody else wants to talk to us. No, stop. Everybody stop. No more discussion.
The chair would recognize J.P. Lemming, who had requested to speak. J.P. Lemming is done, for the record. Did someone call the question? At this time, we will call for public comments. If you want to make a comment concerning this issue and this resolution, you may approach the microphone. It's 3 minutes per person.
Nope.
Speaking off the cuff.
Please state your name and where you're from. For the
Jeannie
record.
Bergen, resident of Fayetteville, 1702 South Harding Place. I am speaking on behalf of Ladies of Grace, and I believe that we are in agreement on this. We do not want this resolution to exclude any of our other faithful volunteers. Yes, we are a faith-based group. We believe in Jesus Christ, but there are many other organizations and volunteers that come into our facility every week, and they have something to offer as well. And I am just concerned that if we make this so narrow, that it will make it much harder to be accepted by the state, to get the funding that we need to keep our facility open. And we don't want to do anything that will hinder that in any way. So I caution you, please don't make it so narrow that we exclude all of our other faithful volunteers. Thank you.
Thank you. Further public comments?
Sherry Main, 15451 Riches Road, Fayetteville. I had to pause and think about what J.P. Washington said when she made the comment about this. And if you're a Christian, it shows outward. I don't think making more words in a resolution is going to make that shine or be outstanding anymore. So I think J.P. Koger's words were accurate, and I think they were sufficient in the ordinance. I think adding more is getting more gray in it. Things sometimes need to be black and white. They do not need to have so much gray to interpret other things between the lines. And I was thinking, I said, well, we could say, as far as that goes, we could say in Christian community values of hearing the gospel of our Lord and Savior. Instead of Jesus Christ. We could put different words in there with the same meaning, but we're still getting into a gray area where we're blatantly excluding other types of religious organizations and maybe people that have faith in a different belief than ours. So I would hate for this body to do this and then upset other people or maybe offend them. So sometimes less is more, really. Thank you.
Thank you. Other public comments?
I'm Laura Marsh from 1834 North Independence Place. So this is such a unique situation because at the prison, we have people from the right, we have people from the left, and we have people in the middle. We have Christians, we have non-Christians, we have students from the U of A who come in and help with trauma therapy. It's just an amazing group of people that I don't know that we would be united on many other issues. And so I think as we were all listening from Ladies of Grace, we so appreciate, Justice Ecke, you're including that. And yes, we shared stories.
Excuse me.
Go ahead.
We appreciate your comments, but you're supposed to direct those to the chair.
I'm sorry. Forgive me for that. Anyway, we appreciate the sentiment because we are a faith-based organization, but we certainly don't want to, as we said, we don't want to jeopardize anything with the state. And, I think it kind of speaks to our faith and how we approach people as well and really who Jesus is. He never forced anything on anyone. We go in love. We go in love. And so hopefully we are that to them. And so anyway, we are comfortable with the original language. And again, we just don't want to jeopardize that. So thank you all for considering something else, but let's make it a whole community, a response to our whole community. Thank you so much.
Thank you. Public comments? At this point, we will have a roll call vote to determine whether this resolution is passed as amended. Mr. Allen, we ask that you would call roll. A yes vote is in favor of the amended resolution. Point of order. We have a point of order. J.P. Koger?
Yes. When do I get, I had an amendment I wanted to remove those words from the ordinance, from my resolution. So what happened to that? Help me understand that.
Okay. J.P. Koger, we don't have a window now to insert your request. We couldn't add it at the time you originally made it, but you didn't bring it up before we got to this point. By the rules of order, we can amend it at this juncture. So the question is, we will vote by roll call, yes, for a vote that supports the resolution as amended. No is of course a vote against that. Mr. Allen, would you please call roll?
Justice Simons? Yes. Justice Bowerman?
Yes, sir.
Yes. Justice Lyons?
Yes, sir.
Yes. Justice Ecke? Yes. Justice Dean? Yes. Justice Koger? Yes. Justice Dennis? Could you repeat that, sir? No. Justice Hires? Yes. Justice Rio Stafford? Yes. Justice Lemming? Yes. Justice Ricker? Yes. Justice Pond? Yes. Justice Taylor? Yes. Justice Wilson?
Yes,
Yes.
the resolution passes. We want to thank everyone for being here tonight. Thank you for the patience on this court. We're not really nearly done, so we want to call a 5-minute recess, only 5 minutes, and then we will re-adjourn. Thank you.
You do not need to mix politics and Christians. Yeah, somebody.
Not yet. Could I have your attention, please? We will reconvene in just a few more seconds. You know. This should.
So what happens if somebody pushes it and pops up here and so do you have to push that or just hit? Okay. You hit somebody accidentally.
We will resume at this juncture. If everyone could please take their seat. We will begin with item number 11 under new business. And we ask, Counselor, would you please read that by title only?
Item 11 is on its first reading, and it is an ordinance amending ordinance 2019-44 to correct an error and for other matters pertaining thereto.
J.P. Lyons, did you want to speak to that? Okay, I have a motion by J.P. Lyons to suspend the rules and move this to a second reading. I have a second from J.P. Dean. All those in favor, please say aye. Aye. All opposed? It moves to the second reading.
An ordinance amending ordinance 2019-44 to correct an error and for other matters pertaining thereto.
Thank you. J.P. Lyons?
Thank you, Chair. Make a motion, we suspend the rules and move this to a third and final reading.
I have a motion to suspend the rules and move this to a third reading by J.P. Lyons. I heard a second. Was it J.P. Rios Stafford? All those in favor? Aye. All opposed? It does move to the third reading.
An ordinance amending ordinance 2019-44 to correct an error and for other matters pertaining thereto.
J.P. Lyons?
Make a motion, we pass this item.
I have a motion to pass this item by J.P. Lyons. I have a second by J.P. Dean. All in favor? I apologize. Okay. Is there any discussion on this matter? Discussion, questions by members of the Quorum Court? Public comments? Seeing none, we will take up the question. This concerns item number 11. Mr. Allen, will you please call roll?
Justice Simons? Yes, sir. Yes. Justice Bowerman? Yes. Yes. Justice Lyons?
Yes, sir.
Yes. Justice Ecke? Yes. Yes. Justice Dean?
Yes, sir.
Yes. Justice Koger? Yes. Justice Dennis? Justice Hires? Yes. Justice Rio Stafford? Yes. Justice Lemming? Yes. Justice Ricker? Yes. Justice Pond? Yes. Justice Taylor? Yes. Justice Wilson?
Yes.
Yes.
Motion passes. That takes us to item number 12. Counselor, would you please read that by title only?
An ordinance ratifying a conditional use permit recommended for approval by the Planning Board of Adjustments for the Round Mountain Fire Station.
Yes, sir, we have a need in that community to place a couple of trucks and some equipment down in that area, as later on in the maybe in this year, there will be some repair work done to a bridge that will make response times a lot longer than they should be. They've done an awful lot of work there cleaning that area up. And it's just gonna be a thing that helps our community be safer. We'll have faster response times, and it's just all the way around. It'll be a good facility. Do we need to suspend the rules and move this up?
Are you making that in the form of a motion?
I move we suspend the rules.
Okay, we have a motion by J.P. Pond to suspend the rules and move this to a second reading. Howard, the second, was it J.P. Ricker? Discussion. J.P. Koger?
Yes, thank you very much. I just want to say that this was just passed out of the Planning Board Commission, I think, week before last. And it makes me nervous when we move these conditional use permits forward on one night, because I'm always afraid that we haven't given the community, the neighbors, time to know about this and to be here to speak either for or against it. So I'll be voting against moving it on to the other readings. Thank you.
Thank you. J.P. Lyons?
Thank you, Chair. Director Ada, please. So when I read the notes from the planning board, there were no, well, first, let's start with, the notifications went out as required by ordinance, correct? And they go out how long before the planning board?
Normally 14 days,
14
and like
days
that's
before
why
the planning
our ordinances, we have to send them 14
And
days.
then do you send
before.
notification before it hits the
Yeah,
quorum court again?
definitely, yes.
Another 14 days prior to quorum court?
Yes, and we haven't received like any objection from any of the neighbors.
And there's been no objections?
Yeah.
Thank you, sir.
Yeah, and it was approved unanimously by like the 7 members of the planning board.
Thank you. Other questions or comments at this time? The motion was to move it forward to the second reading. All those in favor, please say aye. Aye. All opposed? No. Okay, it does move on to the second reading. Counselor, would you please read that by title only?
An ordinance ratifying a conditional use permit recommended for approval by the Planning Board of Adjustments for the Round Mountain Fire Station.
Move to suspend the rules, move to the third and final reading. Second.
I have a motion by J.P. Pond to move to a third and final reading. I hear a second from J.P. Ricker. Is there a comment or question at this point?
I'd like to make more comment on this and remind people this is for a satellite facility for the Round Mountain Volunteer Fire Department. And it's absolutely necessary for the people's safety and health, safety, welfare, well-being, and that it's also given that little part of the neighborhood a facelift, if you will. Thank you.
Thank you. At this point, we will have a roll call vote. You can vote in favor. Okay. We're going to suspend the rules and move. The motion is to suspend the rules and move to a third reading. I'm getting ahead of myself there. All those in favor, please say aye.
Aye.
All those opposed? No. Okay, it does move to a third reading. Started to say J.P. Lester. Councilor Lester, would you please read that by title only?
An ordinance ratifying a conditional use permit recommended for approval by the Planning Board of Adjustments for the Round Mountain Fire Station.
Move to pass.
Second. We have a motion on the floor by J.P. Pond to pass. We have a second by J.P. Ricker. Is there any further discussion? J.P. Lemming?
I just want to tell everybody in Round Mountain and the fire department, thank you for your service, and we'll be getting this passed for you.
Thank you. Other comments? Seeing none, at this time, we will entertain public comments concerning this particular issue. If there are none at this time, we will have a roll call vote. Mr. Allen, would you please call roll?
Justice Simons? Yes, sir. Yes. Justice Bowerman? Aye. Yes. Justice Lyons? Yes, sir. Yes. Justice Ecke? Yes. Yes. Justice Dean? Yes, sir. Yes. Justice Koger? Yes. Yes. Justice Hires? Yes. Yes. Justice Rios Stafford? Yes. Yes. Justice Lemming? Aye. Yes. Justice Ricker? Yes. Yes. Justice Pond? Yes. Yes. Justice Taylor? Yes. Yes. Justice Wilson?
Yes.
Yes.
The motion passes. Item number 13. Counselor, would you please read that ordinance by title only?
An ordinance ratifying a conditional use permit recommended for approval by the Planning Board of Adjustments for the Schlenker Wedding Venue.
J.P. Taylor?
Thanks, Chair. This is a small wedding venue outside of Tawnytown. I think the plan is for around 50 people. Passed unanimously at the planning level. No real objection that I'm aware of other than the normal, traffic, that kind of thing, which I think Director Atta said is sufficient. And I would move to suspend the rules and move to the second reading.
Okay, we have a motion by J.P. Taylor to suspend the rules and move to a second reading. I heard a second from J.P. Lyons. Okay. All those in favor? Aye. All opposed? No. It passes.
Move to suspend the rules and go to a, oh, sorry, go. Read it first, then I'll do that.
Okay. Are you on
An ordinance ratifying a conditional use permit recommended for approval by the Planning Board of Adjustments for the Schlenker Wedding Venue.
I would make a motion to suspend the rules and move to a third and final reading.
I have a motion by J.P. Taylor to suspend the rules to move to a third and final reading. I have a second on the floor by J.P. Lyons. All those in favor? Aye. All opposed? No. It passes to the third and final reading.
An ordinance ratifying a conditional use permit recommended for approval by the Planning Board of Adjustments for the Schlenker Wedding Venue.
I'd make a motion to pass item 13.
We have a motion to pass this ordinance by J.P. Taylor. We have a second by J.P. Lyons. We have discussion. J.P. Koger?
Yes, thank you. I assume Mr. Atta is going to come up and give us some information. And what about the applicant? Are they here? Yes, ma'am. I'd like to hear from all of them. Thank you.
The Slinker Wedding and Event Conditional Use Permit was approved on June 6, 2024 by the 7 members of the Planning Board. The project is in Tontitown Planning Area. The applicant is requesting a CUP approval for a small wedding and event venue on his property. The applicant is in the process of splitting off a 1 acre tract to use for the CUP out of the 10-acre parcel. The venue will be completely outdoors and will accommodate up to 50 guests. There will be 10 by 10 feet platform and a seating area for the ceremony, as well as 63 by 63 foot parking area to allow up to 25 vehicles and handicapped accessible stalls. Hours of operation will be as needed between 10 a.m. to 10 p.m. Saturdays, and by appointment only between 5 p.m. and 7 p.m. during the weekend for rehearsal. The business will operated by 2 employees, mostly the husband and wife. The project is located in the eastern side of Eldridge Road, approximately 0.3 miles from Wildcat Creek. The applicant also desire to have a signage, a maximum 3 by 4, non-illuminated. The applicant have contacted the road department to do some improvement on last Friday, and I believe this Monday the road department crew, they went over there and added more gravel and graded the road, and I guess they're into discussion to see when they're going to be having more improvement on that road as their schedule allows. We had some objections or opposition from 3 neighbors. It's mostly about noise, driving conditions, the roads might not sustain, but it's the same as every project we have. We never had any solid objection from the road department since this is a public road and it's paid by taxpayers. So the applicants are here if you have more questions for them.
Thank you.
Thank you.
Other discussion? Seeing none, we will, I'm sorry, J.P. Koger?
I'd just like to hear what the applicants have to say about how, what will be carried on there. Will there be, are they going to have enough parking for how many people and all that? I'd like to just hear what they have to say about it.
Okay. Let me make a point of a clarification. We are not having an appeal or anything like that tonight. So nobody here who is involved in this process has to answer questions from this body. But anybody who is here to speak publicly concerning this issue can certainly come to the microphone. So I wanted to clarify and make that distinction. So at this point, and I'm sorry, J.P. Koger, was that all that you wanted to say? Yes. Okay. Give me 1 second. Was there any other comment before we go to public comments? Okay, thank you. Public comments, if you would, please state your name and where you're from, and we'd be glad to hear from you.
Am I on? Okay. Mm-hmm. I am Brittany Slinker. This is my husband, TJ Slinker. We are the ones that are going to be doing the venue, if approved. So pertaining to your question about the parking, we do have enough parking. In the area, we have mapped it all out to make sure that we do have at least 25 and more area parking for at least, like we said, up to 50. So there will be, yes, enough parking spots for them. Like he said, there were some questions from the neighbors about mostly traffic and the roads and the conditions. We, after the last meeting, contacted the road department, and they actually came out the next day and graded the roads and added gravel. So we have really good reception from them as far as adding to that. And he's actually in contact with them as well about getting speed limit signs put up. So we're having really good contact with them on that. As far as any other questions on anything like that?
Thank you so much. Other public comments?
Sherry Main, still on Riches Road in Fayetteville. I just have a comment about, since this was not appealed, has the 30, I'm not asking a question, I'm just stating a comment, has the 30-day appeal time gone by before it's presented for ratification? It's my understanding under planning rules that you have 30 days to appeal a planning board's decision before it's ratified by the quorum court. Just want to make sure everything's procedurally correct.
Public comments? Thank you. At this point, we will take up the question. A yes vote, of course, is in favor of this conditional use permit as recommended. Mr. Allen, would you please call roll?
Justice Simons? Yes, sir. Yes. Justice Bowerman? Yes. Yes. Justice Lyons? Yes, sir. Yes. Justice Ecke? Yes. Justice Dean? Yes, sir. Yes. Justice Koger? Yes. Yes. Justice Dennis? Yes. Yes. Justice Hires? Yes. Yes. Justice Rios Stafford? Yes. Yes. Justice Lemming? Yes. Yes. Justice Ricker? Yes. Yes. Justice Pond? Yes. Yes. Justice Taylor? Yes. Yes. Justice Wilson?
Yes.
Yes.
Motion passes. This takes us to item 14 on our agenda. We ask Counselor, if you would, please to read that by title only.
An ordinance ratifying a conditional use permit recommended for approval by the Planning Board of Adjustments for the Bellevue venue.
Second reading.
I have a motion.
Oh, your mic's off.
I have a motion from J.P. Ricker to suspend the rules and move this to a second reading. I heard a second. Was that J.P. Lyons? Mm-hmm. Okay. All in favor? Aye. All opposed? No. Okay. We will move to the second reading. Counselor, would you please read that?
An ordinance ratifying a conditional use permit recommended for approval by the Planning Board of Adjustments for the Bellevue venue.
Make a motion to suspend the rules, move to third and final reading.
I have a motion again from J.P. Ricker to suspend the rules to move this to a third and final reading. We have a second on the floor from J.P. Lyons. All in favor? Aye. All opposed? No. It does pass. We will go to the third reading at this time.
An ordinance ratifying a conditional use permit recommended for approval by the Planning Board of Adjustments for the Bellevue venue.
I'll make a motion to pass.
We have a motion. I'm sorry, go ahead. We have a motion to pass by J.P. Ricker. We have a second by J.P. Lyons. Do we have discussion at this time? J.P. Ricker?
Yes, this is a project that has been moved from one that I objected to originally. It's now just off of East Devil's Den Road, right by the interstate, a good highway access, and it is in what our future land use that we're looking at now is deeming commercial. So I am in support of this. And Director Atta can probably give more information on it.
Okay. Director Atta, could you speak to this at this time?
Hello again. So this project was approved by the 7 members of the Planning Board on the 6th of June. The applicant is requesting a conditional use permit for 5,000 square foot like wedding venue event center with a maximum capacity of 300 people. Typical event will be expected to host between 150 to 200 guests with 1 to 2 events per week tops. However, the venue will have spaces to allow more occasionally. The venue will have 2 employees currently, with a goal to have 4 full-time employees in the future. Hours of operation will be Monday through Thursday from 8 to 4 p.m., Friday and Saturday from 8 a.m. to 11 p.m., and Saturdays from 8 a.m. to 10 p.m., with the main business days being Friday and Saturdays. There will be approximately 125 parking spaces with 5 ADA compliant accessible parkings. The venue is anticipated to provide accommodation for 50 to 75 vehicles in 14-hour period. If this CUP is being ratified and approved by the Quorum Court, it will go, the applicant needs to apply for a large-scale development permit and goes through the whole engineering phase. At the moment, the project property is 37.12 acres. The applicant is purchasing 21 acres and is working on the split, and only 10 acres will be used for this project. And as JP records, this project is on the interstate, and coming from south to north is the first exit to Winslow. So we had no issues. And the entrance is gonna have a big giant truck with lettering on it that says properties here, and with downlit sign on it. So, and we haven't had any objection from the neighbors. Actually, we had 3 letters that supports the project. So we're good there.
Thank you. Does anyone else have questions for Director Atta at this time, or additional comments? JP Hires?
I just have a comment. In the future, could we possibly have these things loaded up on our computers? We just spend a lot of time. I'm not asking, I'm just saying, it would be very nice if in the future we could have these so I didn't spend all the time getting it together. That's all.
Okay.
Thank you. Yeah.
Yeah, just speaking for the map for the future projects we're working on right now, I updated the zoning map this morning, so it should reflect the newest.
We had to get online, we had to turn on the internet, and we had to go to the.
I wish I control it. I don't have I don't control it. Thank you.
Okay. Thank you. JP Rio Stafford?
Thank you. I just wanted to thank the applicant for giving this a second try. I was one of the JPs who originally voted against this when it was at a different location, because it was far from major roads, and there were some neighbor complaints, and I think this is a really ideal location for this, and it sounds like there's some neighbors in favor this time. And this is exactly where, as we look at rezoning the county potentially, this is exactly, as JP Ricker mentioned, exactly in an area where we're going to be looking at doing commercial zoning. And so I think this is a really appropriate area for this, and I think this is a really appropriate use of the land there. And I'm looking forward to seeing it become a reality, and so I'm going to be voting yes this time.
Thank you. Other comments? Any public comments? We welcome those. We just ask that you state your name and where you're from.
I feel like I'm family, but Carolyn Ram, 840 Four Seasons Drive, West Fork. I learned a lot the last time I was here. I prayed a lot after the last time I was here, and the realtor for the previous land that was a debacle actually mentioned this situation to the owner of some land that I had looked at a long time ago, and it was way out of my budget. But things moved forward, the Lord moved, and I heard everything everyone said. This land is at 11448 Abilene Road. It is in the planning zoning for commercial land. The only neighbor is the seller of the property, and he is a proponent of it. I wrote letters to everyone that the Planning Commission sent notification to. I met with one couple who were great about it. I received a great letter of support from another neighbor. And I even received one from a couple who live in Texas, but they have land there, and they too were a proponent. And it's the same story as before. The venue will be a bit smaller because of the $24,000 I lost on the last piece of property. But it's a great opportunity. I think it fits very nicely with the community. I appreciate the positive feedback, and it was very important to me to make sure that I did this right this time, and I was very aware of where it needed to be. And I'll be very candid, I didn't think I'd ever find that land, and it fell in my lap. So thank you, everyone. It's been a great learning opportunity for me. I give God all the glory. It is out of my hand. JP Ricker, thank you. I appreciate that. And I look forward to serving the Winslow community. Thank you.
Thank you. Other public comments? Seeing none, we will take up the question here. We will have a vote in whether or not we support this conditional use permit. Mr. Allen, could you please call the roll?
Justice Simons. Absolutely. Justice Bowerman.
Yes, sir.
Yes. Justice Lyons.
Yes, sir.
Yes. Justice Ecke. Yes. Justice Dean.
Yes, sir.
Yes. Justice Koger.
Yes.
Yes. Justice Dennis.
Yes.
Yes. Justice Hires. Yes. Justice Rios Stafford. Yes. Justice Lemming. Yes. Justice Ricker.
Yes, sir.
Yes. Justice Pond. Yes. Justice Taylor. Yes. Justice Wilson.
Yes.
Yes.
The the ordinance passes. Item number 15 is next, and I ask that the counselor read that by title only.
Item 15 is an ordinance anticipating and appropriating additional revenue in the amount of $122,273.12 in the Law Enforcement Grant Fund for 2024. And I want to point out in the ordinance that was drafted for the committee, there was a Scrivener's error, and it inadvertently had $125,273.12, which did not match the number in Article 2, which was incorrect, and Article 2 is correct. So the correct amount in the Scrivener's error has been fixed and reflected at $122,273.12.
Just one.
No, an appropriation ordinance can pass without 3 separate readings, provided it gets 10 votes in favor.
Make a motion to pass.
We have a motion to pass by J.P. Ricker. We have a second by J.P. Lyons. J.P. Koger?
Thank you. So last week I passed out something from the Department of Justice that said it was just an estimate, and I believe that Dr. Bridget Russell is here tonight, and she's going to talk about that. So maybe we should let her explain how she came up with this number before the discussion, or do you want me to go ahead and discuss it now? I'll just go ahead and discuss it now.
Were you wanting her to come to the microphone at this time?
Well, I was, but
I want that to happen as well. I'd like the court to discuss this first and have her come during public comments.
I'm sorry?
I'd like the court, any other discussion to take place on the court, and then have her come to speak after that during public comments.
Okay, well then I want to speak now, please.
You have something additional that you want to say?
Yes.
Okay, go ahead.
So we have some new people here tonight who may not know what this SCAP grant is. It's the State Criminal Alien Assistance Program. It is a grant according to the Department of Justice, and we get that money for selling personal information on undocumented or reasonably believed to be undocumented criminal aliens, those are the words of the grant. So that information gets turned over to the Department of Homeland Security, and then it goes to it gets turned over to Department of Justice, then it goes to Department of Homeland Security and ICE, and they actually go through each application. And Department of Justice estimated this year they'll have over 500 applications. They have to go through every record to see to determine the eligible inmates, and that process takes several months. We have 45 days from the date we get the email from the DOJ to accept that. Now, for the 25 for this year, fiscal year 24 SCAP grant, it's filed with the Grants Gov, and just grants opened 21 days ago, and the grant period closes 39 days from now. So the amount on the ordinance is just an estimate, and I'm not sure why we're voting on it now when we don't have a set number. It's going to likely have to be amended later. I just want to say that we get pennies on the dollar for selling this information to the Department of Justice and Homeland Security. Last year, it came around to about $8 or $9 per eligible bed day. I can't tell you what it will be this year because we don't know the eligible bed days. So every time this grant comes up for acceptance, we have our friends and neighbors. We hear from them. We've heard from them in the past. They tell us that, in their own words, how harmful this is to them, and that it causes fear and distrust of law enforcement. When someone who is impacted by a policy tells us it is harmful to them, we should listen. They know because they have to live with it. This grant does, in fact, target the immigrant community. Yes, immigrants who have been convicted of 1 felony or 2 misdemeanors, but that subjects them to a 2-tier justice system, the second part of which could result in separation of families and deportations. When you or I go through the criminal justice system, and our case is done, we don't face the additional threat of separation or deportation. We have a sentence and a judgment, and that's it. We do not have to face deportation. That only impacts the so-called undocumented immigrants. So why are we trying to rush this through tonight? Did we have trouble with the deadline from earlier this year when we passed it and when we passed the fiscal year 2023? Why are we jumping ahead with it and passing an ordinance that most likely will have to be amended sometime around October and November, probably just right before the election? Thank you.
Thank you. J.P. Lyons? Try it now.
Thank you, Judge. All right, thank you, Chair. You know, we go through this every time this comes through. This helps offset costs, but more importantly, I continue to hear the unbasis propaganda that this targets people. And I'm sorry, the good men and women of the Washington County Sheriff's Department do not target people, period, plain and simple. And the continuing of accusing them of such is just ridiculous, and you should be ashamed of yourself. They simply provide the information, the program, and what happens to whom is 100% the federal government's decision and discretion. So if it's being utilized improperly, that's the federal government you need to go talk to. They simply take information from everybody that comes in regardless, and no targeting at all. And I will be supporting this as I support it previously and will continue to support it in the future.
J.P. Pond?
I can't begin to say how important it is for government entities to be on the same page, to be able to work together, and particularly when you're talking about law enforcement. I've dealt with entities in the past with permitting on a farm, a small farm, but still had to be permitted, where I had government entities that had opposing interests, opposing opinions, and where I had one entity praising what I was doing. Another one said, you cease and desist, you stop that today. We don't need that in law enforcement any more than we ever needed it in our farming operations. And the only way I can describe it, if you can get those entities working against each other or running around behind each other, it is chaos. But some people like chaos. And I'm looking at you, I'm not looking at anybody else in here. And I also get tired of what I call maybe partial truths. Partial truth is not truth. Thank you. I'll be supporting it.
Thank you. J.P. Bowerman?
Yeah, I take exception with the statement that there's information being sold to the government. I don't believe that's an accurate statement. You know, I do know there is information provided for the reimbursement, but being sold includes intent. And there's no intent here targeting a certain group of people. Now, certainly, people have felt that they were targeted, but there is no evidence that proves that they were specifically targeted by ICE based upon this state criminal alien assistance program. And so I think that when we use language like that, we are alienating those good men and women who are seriously trying to work within the confines of the law in ways that will take things like this and reimburse the county for the cost that we've already incurred by these criminals who are here illegally. I know we like to call them undocumented, and I understand that. I work with a lot of them. But at the same time, we have to understand that when you live illegally and you're working illegally, there are ramifications to that. And these are not people who just got picked up off the street. These are criminals. And that is a very prevalent thing that we have to remember, because I understand that they can be redeemed, and that's wonderful. But I don't know how much that we need to say, let's do that and not take any money for it, even though these services have already been rendered and we've already been paid. So I just think it's important to understand that our language is important, how we say these things. And I think that we need to remember that we shouldn't be accusing people of doing things that we have no basis to prove. Thank you.
Next, the chair will recognize J.P. Ricker, but first, as the chair, let me interject this as a way of procedure. We have to be careful on this court. There's nothing wrong with a healthy clash of ideas. And I think many in the public applaud a robust debate, and that's fine. But I want to ask everybody on the court to be careful. It's not butting heads one individual JP with another, but a clash of ideas is a little bit different. And we want to be careful not to cross the line, and I want to urge people to direct comments towards the chair. We are not, nobody here's in an argument with another individual, so we can all make our case and make our point, but I want to ask that we try to stay within those parameters, which were in place a long time before I was ever here. J.P. Ricker?
I just want to make a couple of statements about this. I've been involved in law enforcement for 40 years. Everybody that gets arrested and placed in the county jail fills out a booking sheet and arrest record, all of which are public information and subject to FOI. That's why you see the arrest reports in the newspaper. That's why you can go on the website and get all the information about it. It's not like we're doing something that's not open to the public for anybody that wants to look at to see.
Thank you. J.P. Lemming?
I just want to thank Ms. Russell for her hard work in finding grants and following up on all this. And these grants they have to be filled out and they have to be sent in by certain times. Yes, if we have to estimate a deal once in a while, we have to do that, but she'll eventually get all the final documents sent to them. And I think the county needs to dig for every grant that we can get. I don't care if it comes from the state, federal government, Walmart, McDonald's, whoever, it don't matter. Because, you know, if we're spending $41 million a year at the jail, we need to get all the help we can get. And I want to thank her for finding grants and keep digging for them. I don't care what it says on the backside of it. I don't think we're targeting anybody in this world. Thank you.
Thank you, Chair. It seems like there's two issues at hand right now. I have no interest in rehashing the validity of the SCAP funding. We've done that ad nauseum at every opportunity that this has come before the court. I am, however, interested in talking about the validity of this particular amount and the timing of it. And I'm concerned about waiting until after this discussion, having somebody come up who's potentially going to enlighten us with additional information and then not being able to re-discuss information that's presented by waiting until we get that information in public comments.
I understand, and earlier I did say public comments, but what I meant was that we would like to hear from Dr. Russell, and certainly not limit her to 3 minutes of public comments. Okay. That was my intention. I know I did say.
So we will hear from her and then have additional opportunity to discuss amongst ourselves.
Or ask a question. Yes, that was my intention.
Thank you, Chair.
But thank you for clarifying that. I'm trying to get to people who have not spoken yet. J.P. Ecke.
Thank you, Mr. Chairman. This grant comes from the U.S. Department of Justice, and it's a program that has been a catalyst for many initiatives that have brought about cost savings to the taxpayer. Excuse me. Funding for these programs provide the foundation for our nation's counties to build robust capabilities needed to fight crime and better manage outcomes for the youth in our area. This is a program, a federal program that is started by the DOJ, intended to help reimburse counties for their expenses in dealing with the incarceration of the illegal immigrant community, regardless of where they're from. And I think that's something that's being missed. This is a nationwide program that is successful to help counties. And it is only a false narrative that builds fear into our immigrant community, rather than building a positive relationship with law enforcement. This false narrative is breeding fear. So this program is intended to help reduce the cost and the burden of all taxpayers, and I'm for it. So thank you.
Thank you. Earlier, I think J.P. Rio Stafford, your mic was keyed, but no need to, okay. Okay, thank you. J.P. Koger?
Yes, just a moment, please. Okay, thank you very much. Okay, first of all, I never said the good people at the sheriff's office target immigrants. I said the grant targets immigrants. The grant is voluntary. We don't have to participate in it. And Mr. Chair, as far as whether or not we sell information, we give information to the Department of Justice, and they give us money back in this grant. That's a transaction. As to no evidence that it leads to harm, there's really no evidence that it doesn't lead to harm. And as a matter of fact, last year, in January this year, 21 Marshallese men were picked up and deported. I mean, picked up by ICE and taken to a holding facility in Louisiana. So that's all I have to say on it, except that I'm going to bring this up. As long as I'm alive and I can speak, I will always speak against this because it hurts people. We should not be participating in policies that harm people.
Thank you. At this point, I'm not seeing others ready to make comments or discussion. I'd like to ask Dr. Russell if you could make your way to the microphone. We would like to hear from you, and I wanted to reiterate that earlier when I said during public comments, you're not limited to 3 minutes. Please explain to us what you feel is most important pertaining to this issue.
Thank you. Thank you for allowing me to speak with you. I'll address a couple of questions that I've heard. So one is the timing. With this grant, we do have some time to accept the funds once we get them. However, the way I've learned, and y'all have known for a long time, the way the system works for scheduling for Finance Committee and General Court, it could cover 3 months easily. And that's without discussion because of getting the timing of everything together. When the grant was released, I went ahead and did the first phase, requested the information from the sheriff's office. They have to pull it to organize it, but as someone said, it's all there. It's all there on the websites of the counties and the jails already, but they have to pull it in a certain format and organize it. That's all they do. When I send that on up, whenever they announce the grants, we'll be able to take advantage of that date, and the sheriff will be able to access the money in a more timely fashion. That's the reason for the acceleration of the project a little bit as far as the asking for the ordinance. The estimated part is simply when you look at the directions, the calculation for the funding, it'll give you a lot of reasons, a lot of things they consider, but the bottom line is based on available funding. So there's no way that I could estimate or that you could estimate, as far as I know, exactly how much we'll get. So in the past, what I've seen in records is there's always been a little bit of an increase each year, and that's why I estimated the number that I did. It's not likely it'll be more than that. So that will probably relieve the need for any big changes. The Sheriff's Department decides the budget for the grant, for the reimbursement funds, because it's where they've used it. So usually it has to go for inmate services, things like training, food, medical, health needs, those things for the inmates that they've already expended money on in fiscal year 22, I believe this year is what we're using. So that's kind of a little bit of an explanation. Do you need anything else? I do appreciate, I had a couple of JPs call me this week and let me respond to my duplication of misduplication of numbers on the ordinance at the Finance Committee. Any other questions that I can
Questions
address?
for Dr. Russell?
Thank you.
Any other comments on the Quorum Court? Public comments on this issue?
Mac Mayfield from 980 Rocky Lane. I remember back in January, I think the report had about 180 names on it, of which over 100 were Marshallese people. And to say that this just works for illegal immigrants is inaccurate because they're not illegal and they're not undocumented. But they can get into trouble. As little as 2 parking tickets can send them back to the Marshall Islands. It's not a false narrative that this creates fear in that community. And I think that anything that makes people afraid of their government and will certainly divorce them from being supporters of law enforcement, if that fear becomes great enough, needs to be reconsidered. Thank you.
Thank you. Additional public comments?
Hello, my name is Gracie Foreman. I live right off Poplar by Easy Mart down there. And I just sort of want to reiterate what Mac just spoke to and add a little bit more context to it. I think that the image that illegal immigrants evokes is a powerful one, and that's a very punchy narrative to me. But like Mac said, I don't think that is true, and I'm no immigration law expert, most certainly. I've held a couple internships within that field, but I'm no attorney and no expert in immigration law. But I would just like to say that 109 out of 187 names that were reported under this program in the fiscal year of 2023 were Marshallese. Marshallese individuals are not illegal immigrants. The word undocumented, I think, could potentially be misconstrued as that. But undocumented does not mean illegal, and people can exist within the U.S. as non-citizens without legal pathways to citizenship. And that would also be constituted as undocumented. And so I think to say that this program doesn't harm people is a difficult conversation to have as well. We know 21 Marshallese men were deported in January 2023. Well, not deported, but held at a local facility in Louisiana. Many of them have now been deported, and their families are still struggling to put food on the table, to make ends meet, and making very difficult decisions on whether or not they're going to go back to the Marshall Islands. And whenever we lose that, it is a hit to our local economy and to our communities and the ability to build them safely and help individuals within them thrive. So thank you.
Thank you. Any additional comments? At this point, we will take up the question concerning this ordinance. We ask that Mr. Allen would please call the roll.
Justice Simons? Yes. Justice Bowerman? Yes. Justice Lyons? Yes. Justice Ecke? Yes. Justice Dean? Yes. Justice Koger? No. Justice Dennis? Yes. Justice Hires? No. Justice Rios Stafford? No. Justice Lemming? Yes. Justice Ricker? Yes. Justice Pond? Yes. Justice Taylor? Yes. Justice Wilson?
Yes.
Yes.
The ordinance does pass. This moves us to item number 16. Counselor, would you please read that by title only?
An ordinance amending the county attorney budget for 2024 and other matters pertaining thereto.
J.P. Ecke?
I'd like to make a motion that we pass.
Second.
We have a motion to pass this ordinance by J.P. Ecke. I heard a second by J.P. Lyons. Discussion, J.P. Lemming?
The money can only be used for this one case, and then it put back in general funds if we don't use it. Correct?
It's correct, yes.
Thank you.
J.P. Taylor?
Thank you, Chair. As someone who does this for a living, as they say, as an attorney, when my client hires another attorney, I stop getting paid. So personally, I take somewhat of an issue with the concept of being the most well-staffed county in the state, attorney-wise, number one. Number two, with the highest attorney payroll in the state, number two. And number three, to then hold the taxpayers to account for us not getting what we're paying for. And so my very strong opinion is that this is a bad ordinance, and I will be strongly opposed to it.
Did you want to speak to that? Okay. J.P. Rios Stafford?
Thank you. This may be more of a question for Mr. Lester. And it's sort of this is like a puzzle that I've been trying to figure out since this first came up. So there were at least 3 of us, I think, who originally voted back in 2022 against the original ordinance that this lawsuit is about. And so those, I think 3. For those of us who voted against the original ordinance, well, actually, I guess maybe for any of us who voted back then, is it possible that our vote tonight could eventually become part of this lawsuit or become evidence in this lawsuit at some point?
Your vote to appropriate money to defend the lawsuit?
Yes.
I don't see how it would have any bearing on the case.
Okay. All right. Thank you.
J.P. Koger?
Yes, thank you, Mr. Chair. Last week, I passed out evidence from the U.S. Treasury Department, a consultant hired by the AOC, and from Deputy Attorney, County Attorney Baker, that all said we cannot use ARPA money to pay for jail expansion. I don't think that we're doing due diligence or best practices by appropriating this money, and the people that I hear from in my constituency is a hard no, and they don't want the money to be used for jail expansion, and they understand that it's not legal under the law. Thank you.
Councilor Baker?
Thank you, Chair. I just want to take exception to the recent comment that I wrote an email in opposition to the concept that the project we're contemplating would be legal. I haven't seen this email, but I can assure you that I'm fully in support of the project and its legality. And it's possible that there is a misunderstanding about the difference between new construction and the project at hand. I just want to clarify for the information of the court that I firmly believe this project is fully legal, and any characterization that I have said otherwise is not the case.
J.P. Ecke?
Thank you, Mr. Chairman. I think there's an easy fix to all of this. Just have those people drop their lawsuit and we won't have to appropriate $100,000. That's all there is to it, you know? And everybody can go along their merry way. Thank you.
Other comments at this time? I will say, I'll speak as a JP one more time, if you might allow that. Every lawsuit I've ever been close to, and we're in a touchy situation right here because we have to make decisions as a body on ordinances such as these. So we're doing our job to discuss it. On the other hand, every lawsuit I've ever been close to, the attorneys will tell you, don't discuss this with anybody, we'll take care of it. So here we are in a situation as a legislative body. We are obligated to discuss and make a decision on an ordinance like this, but the best advice for most attorneys is just keep your mouth shut for now because this is going to be litigated. So we're in a bind, but I think we have to discuss this, make a decision, and move on, and this is my opinion as a JP, but we also have to be wary of if there is something in a lawsuit or if there is something to be litigated, if it is in court later on, you know, the attorneys can handle the situation much better, as I understand it, the less that we comment on it. And I hope that makes sense because it's a paradox, but it is what it is. Are there other comments to be made at this time by the court? J.V. Simons?
Thank you, Chair. Just two considerations. One, I'm curious as to what the balance of the special legal line item in the county attorney's budget sits currently. And the second item is, if we appropriate $100,000 for the 2024 budget and this litigation carries over into next year, we're going to be faced potentially with putting additional funds back in for 2025.
So I don't know the figure in the special legal line item. What's paid out of that is for our two FINS officers, and that's the only money that's appropriated into that account. And so all of that money that's appropriated is also then encumbered so that nothing else comes out of that by the comptroller's office. And so, yes, in theory, if this goes over into the next year, then there would need to be another appropriation. You know, that anything unused would go back into the general fund at the end of the year sweep, and so money would have to be appropriated back in to the account to continue that. And just let me say that, you you know, there's always a chance that there is somehow somebody's going to raise a big issue of conflict. You know, as the county attorney under FOIA, we don't observe the same confidentiality that other non-governmental attorneys do. And so there are times, there are abilities for people to get communications, and then it's up to the court whether it considers it as confidential or not. I mean, the rules of civil procedure certainly aren't, don't take FOIA into account, but there's always those issues. And so this is kind of insurance for us that those issues won't hinder this litigation regardless of what anybody says about it. I wish we were like Pulaski County and had about 9 attorneys on staff, but we don't, so.
At this time, we must ask if there are public comments concerning this issue. If there are, you could make your way to the microphone.
Just Road in Fayetteville. I have a couple of comments on this. $250,000, approximately $250,000, is Washington County's salaried budget for a county attorney and a deputy attorney. And we have, or this body has in the past, allocated to the special legal line other funds for lawsuits. I think $20,000 was given to that special legal line in the attorney's budget as well for another particular lawsuit. My suggestion is to take the legal fees from the unappropriated ARPA funds to fund the position of the quorum court. If it's right, and you did correctly use the funds for the jail addition, I'm not saying it's right or it's wrong. You're in a gray area. I mean, IRS, I deal with them every day. It's gray, very gray, not black and white. You can read between the lines, you can read more in the lines. So I'm not saying this is correct to use the money for this or it's not correct. I'm just saying if this body did the correct thing by taking the opinion of the 2 county attorneys that we have on staff and use the ARPA funds, the unappropriated ARPA funds for this purpose, then it should be appropriate to fund that position with the unappropriated use of the ARPA funds. Thank you.
Thank you. Additional public comments? Seeing none, we can take up the question concerning this ordinance. Mr. Allen, would you please call roll?
Justice Simons? Yes. Justice Bowerman?
Yes.
Yes. Justice Lyons?
Yes, sir.
Yes. Justice Ecke? Yes. Justice Dean?
Yes, sir.
Yes. Justice Koger? No. Justice Dennis?
Yes.
Yes. Justice Hires? No. Justice Rios Stafford? No. Justice Lemming? Yes. Justice Ricker?
Yes, sir.
Yes. Justice Pond?
Yes.
Yes. Justice Taylor? No. Justice Wilson?
Yes.
Yes.
The ordinance passes. At this time, you can see the committee reports are on the agenda. Those have been provided. You may look at those more carefully